So, 3. We'll be given a full presentation once all the jurors are here.
I just wanted to say hello to everybody. My name is Linda and I'm a researcher and a member of the Justice Council, so I'm here today to see how things go and to just get a sense of how the experience is for everybody. So I might not behave like a juror. I've got my phone on my desk, for instance, so I'm typing, and that's because I'm just sort of taking notes as I go. After today, you will get sent a questionnaire by my research team. We'll just ask you for some feedback. It's quite easy to fill in, a lot of pre-coded answers. But there are also lots of spaces for you to just sort of express some opinions about what could have worked better or what the ambience was like, whether it feels like a courthouse, etc. So we'd really appreciate it if you could fill the questionnaire in, because we're feeding immediately back to the Lord Chancellor, who's really interested in what's happening today, and we're hoping that this could be rolled out. This is the 4th one we've done, and we're learning every time we change the process. Slightly every time we do it. So thank you so much for volunteering today. Thanks on behalf of Justice, and if you could also fill in the questionnaire, that would be great. Okay, thanks.
I'm the NPMI technician and I'm your link to the virtual courtroom. I'm positioned just through the paper, behind the paper in the kitchen, and I'll be providing support to you throughout the day. I'll have visibility of your video throughout the day, except when you're deliberating. So when you're deliberating, that's you're in on your own and no one can actually look in and to see how you arrangements go. You'll be joining the virtual court through your individual desk, as you probably see on the left-hand screen. You can see yourselves on there. And then, as the court starts, the relevant parties will appear in the other boxes. There will be assigned a juror number, which is pretty much, I think, the number going to be the number on the front of your desk. So, at your desk, you'll find two screens. These will show you the virtual courtroom and the documents referred to in the case. So, as I said, the left-hand screen is the virtual courtroom, the right-hand screen is if there's any videos or documents, evidence that needs to be shown, they will be put up on that screen for you to view. There's a webcam on the top of each on one of these screens, and that's just to ensure that the other participants of the court can see. There's a headset. This will let you hear what's playing, what's taking part in the actual virtual court. It's much easier and more comfortable to put the headphones on than rather than playing across the speaker. There's a document pack, as you see in front of you. You can open that and read through it at your leisure. Okay. You're allowed to discreetly have a drink with you on your desk, but please only do during the breaks. 5 minutes before the trial starts, I'm going to ask you to switch off your mobile phones. You may not use your mobile phone in session, but you can do during the breaks. At the beginning of the trial, 12 of you will be chosen to act as a jury. If you're not one of the 12 chosen people, please leave the hall while they're using it. A link will be provided by email to the public gallery, and you're free to watch the proceedings from home. During the trial, if you need a comfort break or you have a question for the judge, please raise your hand. I will then enter the room, and you can inform me if there's a question for the judge. We're going to use the tablet device to send the question to the judge. The tablet device will be handed to you inside a clear plastic wallet. You can just type your note onto the device, we press send, and that goes to the judge. When that's taken out of the room, the plastic wallet is then discarded and a clean, sanitised one is used to the back into the next question. Once it's sent to the judge, if appropriate, I will let you know the answer once I've received it. Possibly the judge will give the answer over the video call. There is a jury bailiff who may wish to speak to you at points during the trial. If this is necessary, she will be brought into the screen and will talk to you from there. The toilet is situated in the lobby. As you see, there's 3 toilets in the lobby. And there's no fire alarm test today. If you hear one, please exit the building calmly through the exit. For this purposes, the muster point is outside the church in the car park. And as we all probably know by now, we must be mindful of social distancing. Do not get too close to each other. Okay, what I'm going to do now is I'm going to play a video for you. You don't need your headphones because this is going to be played over a speaker. And that's just to explain your role as a juror and explain the court. So we're just going to set up the speaker so we'll play that. The first, I think, couple of minutes is just an audio. It's going to be on your right hand screen, it's just an audio, but then you'll see it come into the video and you'll see people talk. Okay. So we'll do that and then see if you've got any questions after that. Okay.
You're about to enter the virtual court. Although this is an online proceeding, it is just as real and important as any case heard in person in the court building. This video will show you what the virtual court looks like and where each participant is located. If you are a witness, you will receive an information sheet for witnesses which you will appear in the middle of the screen on the right, between the judge and defence advocate. If you are a juror, this video will show you where you will appear. It is very important that when you join the court scene, you are in a quiet room on your own and stay that way for the duration of your part of the case. The court cannot be interrupted and you must not be distracted. Please turn off your mobile phone and close any emails and other applications on your computer. Thank you for coming to court today to carry out an important public duty.
I am a juror. Before the hearing, the members of the jury are sat in a virtual jury room and run through technical matters with the jury bailiff and the court clerk. When the court is ready to sit, the court clerk transports you into the virtual courtroom. When you enter the virtual courtroom, it is immediately apparent how the courtroom is laid out, as everyone is clearly labelled. It is very easy to watch proceedings and view the witnesses and defendants giving evidence and the barristers making submissions and giving their speeches. The evidence and speeches are as easy to follow as in a real courtroom. A juror can also ask a question of a judge by using the chat function. The jury can also view documentary or video evidence at the same time as viewing the virtual courtroom. At the conclusion of the defence case and the judge's directions, the court clerk moves the jury into a private virtual deliberation room to discuss their verdict and elect a jury foreman. No other person is able to view these deliberations. In the private room, the jury are able to take it in turns to discuss their evidence and exchange views. If necessary, using the chat function, the jury can request to re-enter the courtroom to ask questions of the judge. When the jury have reached their verdict, the jury uses the chat function to notify the court, and the court clerk moves them back into the virtual courtroom to give their verdict.
I'm the judge, but my function in the trial will be to say a few things to you at the beginning of the case about your function and some of the important aspects of it. During the trial itself, I shall be as quiet as I possibly can be, because my function is really to control the proceedings if necessary.
What's the audio at the moment?
It's they're watching the video.
But in time it may be necessary for me to give rulings or make decisions. And if I do have to do that, it will be generally done without you being there, because it's better that you get the product of the legal debate that we might have to have, rather than having to listen to the debate itself. At the end of the case, I'll sum the case up to you by telling you what law you have to apply to it. You'll be assisted by that, because I will give you directions of law in writing that you'll be able to access when you retire. And I will also, to the extent necessary, remind you of the important parts of the evidence that you have heard. And that's really the top and bottom of what I have to do.
Hello, my name is Mark Trafford. I'm the prosecution counsel in this case. And as the expression goes, I bring this case on behalf of the Crown, on behalf of the state against the defendant who you are here to try. My role is to call the evidence that the Crown intends to rely upon, and that will either come through live witness, that is to say, witnesses who will come before you in this virtual court to give live testimony, or on occasion I shall read a couple of statements, which means that it's agreed evidence. Before I do this, I will in fact open the case to you, which means I will explain what this case is about, the background and what the facts of the case are, in very short summary terms, so it allows for you to contextualise what happens when the evidence actually comes. And at the end of the case, I will make a closing speech to you, summarising again what the prosecution's case in relation to all the evidence that you would by then have heard in this case. That is my role.
I'm a defence barrister who represents the defendant, who is next to me on the screen. We have an opportunity to speak privately before the trial and at times needed during the trial. I cross-examine the prosecution witnesses and call defence witnesses, and the defendant should you choose to give evidence. At the end of the trial, I speak directly to you and explain what the defence case is as far as we see the issues at the end of the trial.
So there's going to be a few minutes before the trial. The trial's not due to start for another 25 minutes, unfortunately. I thought I'd just go through it, just bring in to show you what, if you have any questions, just to let you remind you that if you have any questions during the trial, if you raise your hand, someone will, I'll see, or the judge will ask me to come into the room. This is the tablet device that we're going to use for the questions. So what I'll do is I'll hand this device to you, and it's all open and ready, and all you need to do is type your question, and I'll direct you where you press the send button, and that will go directly to the judge. Okay, and then what we do is we remove this, last one, and then give you a clean platform. Okay, I'm just going to ask to say, juror number 1, can you see yourself on the screen? Could you move yourself either up a bit so you're more central, closer to the screen, maybe that's perfect. So when the trial's running, if you could just be a little bit closer to the screen, that would be great. So, does anyone have any questions?
How do you eliminate 3 jurors?
16,
and we only need 12?
Yes, that will be done through the virtual court. That will be decided, and you'll be notified through the virtual court who is staying and who's going forward through that.
What are the criteria?
Right?
What are the criteria?
I don't know. That's not unfortunate. I'm just on the technical side and the assistant side, so that will be explained. That will be explained to you. I can find out for you.
And is everything safe going to be recorded?
Yes. This is streaming and it's streaming on. You can get, so if you're not selected, then you will get a link to a YouTube stream that you can watch from your home. That's the rest of the trial. Okay, so I'm going to pop back in 5 minutes before the trial starts, just to ask you to switch your phone off and make sure everyone's happy. But in the meantime, please.
Could I use the toilet?
Yes. Yeah. I'll open up these doors now. Let me just light a little bit there. You can get outside. Please, if you do step outside, please return to the desk that you just had that.
No.
That's interesting.
Hello. Judge?
Hi, Mark.
Judge, turn your mic on. Judge, your mic.
The judge's mic is on, it's just very quiet, Mark.
I can't hear him at all.
Mark, can you hear me okay?
Yes, completely.
Okay.
Can you hear the judge?
I can, albeit very faintly.
Morning, ladies and gents. Can you hear me?
Morning.
Yeah.
This is the disembodied voice here. Sorry, Your Honour. You are very, very quiet at the moment. Could I ask you to disconnect and reconnect to the call, please? We'll just see how we get on with that.
Okay, that seemed to go fine.
Mark, can you definitely... Yes. Is my background okay? Is that sufficient?
Totally
Absolutely fine. Perfect.
Okay. My chair is sticking out the back of my head. I'm sorry.
Still can't hear him.
Morning, Your Honour.
No.
Okay, I will... could you... I will connect to you directly, and I'll see if we can speak. You should be able to hear me at least.
Mark, I sent you a note, re bad character.
Yeah, thank you for that. I haven't actually printed it or anything, but
it was only just so everyone knows what I was going to say, rather than commenting on it.
Yeah, I'm a bit nervous. Alistair can't hear anything. I think he can hear, but he can't speak, which means he needs an external mic. Yeah.
It's so funny because I actually feel really nervous.
Me too.
Do you?
Yeah, but I always do. I mean, I
know, exactly. I do. Like, it never goes, does it? Even, like, last night, because you prep it like, you know, this is like a real... I prepped it like it was like a real trial.
Well, it is.
I know, exactly, but it's sort of... It's just funny. But yeah, nerves.
wonder if the judge has his old computer. Good morning, Madam Clerk.
Good morning, Judge. How are you? Good morning, Counsel.
Good morning.
I fished out my old collar from the Old Bailey that I'd kept for posterity. So I thought I'd wear it.
Funny is I remember you being my clerk at the Old Bailey.
I remembered you the first day. I don't know about Mark, but I didn't know whether you'd recognise me or not. Now you see me in the garb.
No, I recognised you straight away. Yeah.
All right.
There's a little... Everything's gone swimmingly, bar one small, perhaps important matter. We can't hear the judge. But I think that's being resolved. At least I hope it's being resolved. I think he's got a computer. That may be the issue. And he's now gone, so...
I know.
Right, I'm going to try and put my screen so that our courtroom that we're in now is on the left-hand side and the prompts are on the right, so that I hopefully will remember how to do this and do it properly for us all.
Okay.
So, let's see.
Well, everyone seems to be busy apart from me. I feel left out.
You're so well prepared.
That was right. Where are you sitting at the moment? Are you at home?
Me?
Hmm.
Yes. Is it okay, the view that you have?
Very good. Is mine okay?
Yes, you're both looking very well.
The makeup.
I live in a room in a shared house, so I'm confined to my bedroom, whether I want to isolate or not. So I'm presently on my bed against the side wall with laptop on a tray in front of me. But quite comfortable. Memory foam mattress.
Well, it'd be nice to have the judge online.
With his banner behind him.
Louise? You've muted your microphone, I think.
Sorry, what did you say?
I get nervous when I can't hear people.
I know, sorry, I won't change the sound.
Good morning, Madam Jury Bailiff.
Good morning, sir. I have my gown honest.
Oh, lovely.
I don't think this case would normally silk, but who
did work here?
Did you read The Economist, Louise, that was sent?
No. Oh, yeah, no, I did. Sorry, what you said this morning?
Yeah.
What did he say?
The Economist newspaper wrote an article today which says, I'll just get to the end, an optimistic estimate suggests they'll only be able to hear half as many trials as usual. The end of a long article. As well as the judge, jury, and sometimes several defendants, each trial involves a phalanx, no less, of barristers, solicitors, court officials, witnesses, victims, relatives, journalists, and the merely nosy. Keeping them apart is tricky. And then it says the end. Innovations in order. One option is to shrink the size of a jury, perhaps to 7 members. That's unlikely to help much, since courts will still require overstill space for observers and jury deliberations. A more radical alternative would be trial by judge alone, but lawyers and even many judges have ruled it out. Justice not only must be done, but be seen to be done, says Simon Davis of the Law Society, who represents solicitors. The third idea is to establish mega court bigger venues. There is talk of positioning empty London theatres. You can imagine some of our criminal barrister friends loving that, quips one observer. Well, I can name them. The best solution, right? This is The Economist. Morning, Judge.
Morning, Judge.
We can't hear him. He's got a problem with his.
Oh, dear.
He might have to use his old computer. I'll see. Yeah.
Oh, dear. Do we know if the witnesses are swearing on oath or affirming?
I don't know. I think probably we'll just have to ask them.
Right. No, that's okay.
The defendant, so it's this. I told him he had to take a Bible to work with him, and he wants to swear on the Bible.
Lovely.
Is that okay?
Oh, no, it's no problem. I got all the oaths in front of me just in case.
Catherine, are you okay with opening court?
Yes, no problem, so long as you... As the judge knocks, I was going to start it then, so he can then switch on once I've finished, if everyone's happy with that.
I was just actually thinking, with you being Welsh, me being Northern Irish, have we anyone Scottish in our little team? Otherwise, we're fairly broad representation of the UK.
Well, I'm Northern.
Well, you're close to it then, yes.
That'll do.
I'm a quarter British, as you can tell by my accent.
I still get the court in Northern Ireland, the court service, because I used to work for them before. I still get them ringing me, emailing me and asking me queries about how we do things in England so that they can do things in a similar way, which is lovely.
That is good.
Mm.
I wasn't going to close court. Is everyone okay with that?
Mm.
Yeah.
Only because obviously it'd be... I don't know how to in the circumstances.
The reason I volunteered you was because I was always used with my usher opening court for me, where I was, and I can't remember the court opening. I tried and I couldn't remember the words.
I think I've got 5 minutes. I'm going to leave court unless anyone shakes their head.
Sorry?
Can you hear me?
Yes. Yeah.
I'm going to leave. I'm not going to turn my thing off. I'm just going to leave the room.
Mm-hmm.
So, excuse me one moment.
Can't cope.
My stress levels are sky high.
I know, and mine.
You're on mute.
I'm not, am I? No.
No, Louise.
Oh, right.
I feel exactly the same. Last night I was sitting there thinking, I've got a trial tomorrow.
Yes. And I think it's the fact that they're telling us, oh, we're live streaming this. And the whole world.
That's the bit I don't like.
I know.
That's the bit I don't like.
So whenever we're doing the jury, I've been given the 3 names that we need to leave out. How do you think I should do it? Should I hold the cards up, or should I just, you know, show the card in some way?
I just say number Joe Bloggs.
Yes. So I've got people who I need to have in. I don't need, so for my own assistance, I've done this.
Yeah. You wouldn't show, you just click that.
I'll just do them.
Yeah.
So
because we can't see you shuffling them now, so you can do what you want in the camera shot.
I can just continue to do what I would have done before. Is that all right? Just to show that I'm turning them?
And then shuffle them, as you say, and then put them down and pretend you're calling them one after each other, isn't it?
Yes.
Only you can do sleight of hand.
Yes.
Oh, that's all we want now, the judge not to be able to talk.
Whenever we were on the test call yesterday, my link just completely went. Did that happen to everybody?
No. Apparently I got good signal down here in Wales.
I'm looking at my fringe. I hacked that a couple of weeks ago and I think I haven't cut it straight.
Oh, so I sprayed my roots the beginning of the week. I'm just checking if that I don't.
The things we do when we're on TV.
No. Luckily, I had my hair done the week before lockdown, so.
You see, this is where I miss the wig. The wig had a multitude of sins. As long as your eyebrows were straight, the rest of it was fine. So yeah, but
I got to be honest.
It's the thought that this is going to be played as an example going forward.
Honest to God, I didn't know that.
How we could streamline. And it's going to be on the justice.org page.
I better go brush my fringe.
Be fine. The minute you shake your head, it'll go anyway.
No, believe me, it won't with my hair. I like seeing myself on the screen, that's the problem. If I didn't have to see myself on the screen, I'd be okay.
I'm going to be sitting, I think Louise will recall my poker face. I'm going to be sitting with the poker face on. So many barristers used to say to me, you have such a brilliant poker face. You just sit there and you do not know what you're thinking. You can't work it out.
Brilliant. I don't have a poker face. I have to confess.
Thank you, Louise. Open.
Okay.
Oh, right.
Morning, ladies and gents who I haven't already spoken to.
Good
morning.
Your Honour, hopefully you are with us.
I certainly see and hear you. Can you hear me?
Yes.
Yes, we can.
Yes.
Fantastic, loud and clear.
I've got a thing on my screen. I think getting you out of my computer. I'll just okay.
Yeah, that's fine. Yeah, okay, then that's fine. Absolutely fine. Yeah. Thank you.
Yeah. So you can all see it. You can see me. You can hear me. All is well.
Loud and clear.
Yes, thank you, Your Honour.
And Your Honour, just to make everyone aware, gallery is connected.
Yeah, as agreed, drop out sight and sound.
Fantastic.
The jury are shown on the screen at, I hope, 10 o'clock. How's that?
Yes, if you knock, Your Honour, and then I'll open court, and then
exactly. Enable, make a knocking noise, and then I'll unmute, if that's the right word, the video. in that order.
Your Honour, sorry, that will be prior to the... So we'll have you in the courtroom first and then we'll bring the jury.
Okay, that's fine. Then at 10 o'clock I will do that.
Thanks.
Jury order. Thank you. See you all then.
Bye, Judge.
Yeah.
All persons having anything to do before Her Majesty's Crown Court, draw near and give your attendance.
Thank you very much. Now we have the defendant, I think, with us.
Morning, Owen.
Good morning.
This is the Crown against George Drew for trial, Your Honour. Are you George Drew?
Can we just pause for a moment? Just pause for a moment, if we may. Mr. Drew, you obviously can hear me. Can you see me?
Yes, I can.
And you can see the other people on screen, prosecuting counsel, defence counsel, your own counsel, obviously, me, the court clerk, and the jury. Very good, thank you.
Yes, I can.
Yes, thank you very much, Madam Clerk, if you carry on. Thank you.
This is the Crown against George Drew for trial, Your Honour. Are you George Drew?
Yes, I am.
And can you please confirm your date of birth and nationality?
I'm British, and it's the 30th of September 1979.
Thank you.
Good. Can we bring the jury panel into court, please? Good. Good morning to all 15 of you. What we're now going to do is to select 12 of the 15 of you and those 12 will be those who will serve on the jury. I confess to having been watching the early part of your service here as jurors when you were given some instructions and advice. And one of you I know asked, what are the criteria for the selection of 12 of you? The answer is that there is no criterion at all. It is absolutely purely random. And so the court clerk is now going to make a random selection which will produce 12 of you to serve on the jury.
And Your Honour, may I interpose at this stage, and forgive me for doing so, I hope you can hear me.
Yes, I can.
We had a moment ago on the prison link, the defendant, and at the moment we seem to have lost a video to him.
Oh, all right, well, it doesn't really matter where he is, does it, Mr. Trafford?
Of course not.
No, well, thank you. Let's find out what's happened. The link is broken down.
Thank you.
Mr. Drew, we can't see you. Can you hear us?
The
I'm just going to shut you out for the moment while we resolve the technical issue. We'll come back to you in a moment. If the jury could, as it were, return to their virtual space. Yeah. Good. What's the problem, please?
I have information.
No, I know the problem. We can't see the defendant. I'm asking the technical people what the problem is and what the solution is. Yeah.
Your Honour?
Yes. Hi. Yeah.
Apologies. It looks like the court side is disconnected. We're speaking to the court at the prison side is disconnected. We're speaking to the prison team at the moment, getting the call reconnected in.
Can I encourage people to use phraseology such as the place where the defendant is? It's unhelpful for the jury to know that he's actually in prison.
I agree.
Yeah. No.
Can you unmute me, please? Leave it, Chris. Leave it.
Good. We lost you, Mr. Drew. You can hear us, can you?
Yes, I can, yes.
And you can see us in the same way as before?
Yes.
Good. I don't know what stage you dropped out, but we've done nothing significant. We're just about to make a random selection of the jury. You perhaps were aware of that. Okay. Thank you very much, Lee. Then we'll bring the jury back in, please, and proceed to make the selection. Okay, sorry, Mosero, slight delay. I think someone pressed the wrong button somewhere, but I think we're all here in our correct virtual spaces, and we can now move on to make the random selection of the 12 of you to try the case.
Members of the jury panel in waiting, will you please answer to your names as I call them? Sarah Canby? Michael Collins?
Yes.
Lynn Coward?
Yes.
Claire Hodgson? Ben Dugan McGill?
Yes.
Cynthia Jane Johnson?
Yes.
Evie Crosby?
Yes.
Michael William Canby? Charlotte Bynes?
Yes.
Rupert Watkins?
Yes.
Bruce Alistair Mark Johnson?
Yes.
Albin Anto? Albin Anto? Can I just confirm Albin Anto?
Could you raise your hand if you're that person? No.
Albin Anto.
All right, well, then move on to the next one then.
That's the 12, Your Honour.
Right, but unless I'm missing something,
Have we got everyone who's been called?
We have.
We have 15 jurors, and I have called 12 names, Your Honour. Do you wish me to go through them again?
It's just the last name. It's my fault, perhaps, that I didn't see that person confirm their presence. Albin
Anto, would you please raise your hand? No indication, Your Honour.
Okay, well,
would you like me to select from one of the other three?
Yes, please do. Yes, thank you.
Janet Leeson?
Yeah.
Thank you. George Drew, the names you're about to hear are the names of the jurors who may try you. If you object to them or to any of them, you must do so before they are sworn, and your objection shall be heard.
Now, before we come to that part of it, the taking of your oath or affirmation, it's usual, and we'll do it in this case, to read out the names of the controversial witnesses who are to give evidence in the case, just in case they're people that you may have heard of. I suspect it's extremely unlikely, but we'll go through that process nonetheless. Mr. Trafford, the names of the, I think, 2 witnesses that you propose to call are...
Your Honour, that's right. Just Joseph Black, principal witness, please, and Lee Wilson.
Joseph Black, Lee Wilson, these are familiar names to any of you. Up with your hand. No, thank you. Miss Oakley, I don't, of course, bind you in any way at all. Your client has absolutely free choice as to whether he gives evidence or not, and indeed as to whether he calls any evidence. But the jury can see the defendant and they know his name. Important members of the jury, if you know the defendant, either by name or by sight, you indicate that you do. Thank you, no indication. And is there any witness that you may call? I absolutely understand you're not bound to, but if there is one, perhaps you could let us know the name.
Your Honour, there may be one witness. It will be Bernie Stevens.
Bernie Stevens. Again, no hand is raised. Okay, thank you very much indeed. We'll now move on to the point at which you take your oath or affirmation.
Members of the jury, you're about to be sworn. Will each of you, as I call your names, take your holy book in your raised hand and read aloud the words of the oath on the screen before you, or take the affirmation reading the words on the screen. Sarah Canby.
And forgive me, I'm so sorry to interrupt, but the particular person taking the oath must be unmuted so we can hear it. Should we try that again?
Sorry, ladies and gents. Sorry, Your Honour. This is the technical support.
Yes.
I understand we do have a slight problem with the jury list. Could we just break for a couple of minutes to sort that out, please? It may need some discussion in court, and I will ask for the audio for the jury to be removed.
All right. Okay. Then we'll do this. I'm so sorry, members of the jury. We will get up and running properly in a moment, I'm sure. But these technical problems do arise, I'm afraid. We're going to send you back to your virtual space and get it resolved. And the problem is?
Your Honour, may I make the submission? I understand from my own notification system that I have that it may be that a different jury list, which sometimes happens in physical courts, as you know, may have been used, and that therefore one or two of the names may have been the wrong names from the panel of 15.
All right, okay.
I think probably that can be resolved. It's a pretty common feature fairly quickly.
I have 3 different lists.
I see. Okay, I have to confess that I because one always assumes that people will acknowledge their identity, as it were, that it was only when the last one didn't acknowledge his or her identity that the problem arose. Okay, which is the correct list then? This is very difficult for you, Madam Clerk. I understand that. Sorry, there are 3 different. I mean, I don't have these. I'm doing this blind. There are 3 different lists with 45 different names, 15 per list, or are there different combinations, or what?
Can I just check, is the public gallery still on?
Yes, this is a public process, and the public are entitled to see this.
There are 3 different sets of names.
And they're all
because certain people had dropped out.
I understand. Have you any way of telling which is the most up-to-date of those lists?
Yes, I'll search for them now, Your Honour.
Okay, thank you. How are you doing?
I'm just waiting for a correct copy to be emailed to me now, Judge.
Okay, thank you. just while that's being done, when the jury panel come back, can we unmute them so that they can be heard to say yes when their name is called? And indeed, so we may hear them when they take their oath or affirmation.
Yes, Your Honour, we'll arrange that for you.
That's excellent. Thank you. Thanks. Okay, I'm really sorry about the jury. There has been a complication about the identity of the people on the jury panel. We're just going to start the process again with what I think is now an up-to-date list of those who are part of the panel. There's been more than one list, and I think we've been working off the wrong one. Now, you've been unmuted, so we can hear you. So if and when your name is called, can you say loudly and clearly, yes? Madam Clerk, I've certainly just been emailed myself the list. I think you've probably got it yourself, have you?
Yes, Your Honour. What I'm doing is I'm now organising the cards that I have to make sure that the names that should be there are there.
Right. Are we there?
I'm just doing them now.
Okay, thank you.
I think I'm ready to go now, Judge.
Good, thanks very much indeed. Okay, right, we'll start again then. Thank you.
Members of the jury, members of the jury, will you please answer to your names as I call them? James Aitken.
Yeah.
Thank you.
Rupert Watkins.
Yeah.
Sarah Canby.
Yes.
Kitano Sami.
Yes.
Bruce Alistair Mark Johnson.
Yes.
Michael Collins.
Yes.
Claire Hodgson.
Yes.
Ben Dugan McGill.
Yes.
Lynn Coward.
Yes.
Cynthia Jane Johnson.
Yes.
Eve Crosby.
Yes.
And Charlotte Bounds.
Yes.
Good. I've already dealt with whether you know anybody to be a witness or know the defendant, and I have your answer. So we can move on to the next stage, which is the taking of the oath or affirmation.
Members of the jury, you are about to be sworn. Will each of you, as I call your name, take your holy book in your raised hand and read aloud the words of the oath on the screen before you, or take the affirmation by reading the words on the screen. James Aitken.
I solemnly, sincerely and truly declare and affirm that I will faithfully try the defendant and give a true verdict according to the evidence.
Thank you. Rupert Watkins.
I solemnly, sincerely and truly declare and affirm that I will faithfully try the defendant and give a true verdict according to the evidence.
Sarah Canby.
I solemnly, sincerely and truly declare and affirm that I will faithfully try the defendant and give true verdict according to the evidence.
Thank you. Gitano Sami.
I solemnly, sincerely and truly declare and affirm that I will faithfully try the defendant and give a true verdict according to the evidence.
Thank you. Bruce Alistair Mark Johnson.
I solemnly, sincerely and truly declare and affirm that I will faithfully try the defendant and give a true verdict according to the evidence.
Thank you. Michael Collins.
I solemnly, sincerely and truly declare and affirm that I will faithfully try the defendant and give a true verdict according to the evidence.
Thank you. Claire Hodgson.
I solemnly, sincerely and truly declare and affirm that I will faithfully try the defendant and give a true verdict according to the evidence.
Thank you. Ben Dugan McGill.
I solemnly, sincerely and truly declare and affirm that I will faithfully try the defendant and give a true verdict according to the evidence.
Thank you. Lynn Coward.
I swear by Almighty God that I will faithfully try the defendant and give a true verdict according to the evidence.
Thank you. Cynthia Jane Johnson.
I solemnly, sincerely and truly declare and affirm that I will faithfully try the defendant and give a true verdict according to the evidence.
Thank you. Eve Crosby.
I solemnly, sincerely and truly declare and affirm that I will faithfully try the defendant and give a true verdict according to the evidence.
Thank you. Charlotte Bounds.
I solemnly, sincerely and truly declare and affirm that I will faithfully try the defendant and give a true verdict according to the evidence.
Thank you. Members of the jury in waiting not called, will you please raise your hand and follow the usher's instructions for leaving the virtual court?
Your Honour, we'll just require a short second. Your Honour, sorry, we'll just require a short second to remove the juror screens. The jury will be removed from the courtroom just while we do that.
All right.
Thank you.
Okay.
We are ready to be brought back in.
Good, thank you. Now, members of the jury, nice to see you back again, the 12 of you. I need to say just a few things before we embark on the trial proper. The first, I think, has to be, I'm sorry about the slight delay that we've had. There is always something, so don't rush away and say it's because the technology is no good. It's not that. There's always some problem with any trial starting on time. I promise you that I speak from experience. Not sure I want to own up to this, but the first trial I presided over was on September the 1st, 1986. I was extremely young, obviously. And I don't think I've ever presided over a trial that actually started on time ever, for whatever reason. But I'm sorry, but we will make up time, I have no doubt. Okay, as I say, one or two things to say to you. The first and most important of them is to emphasize to you that your safety has always been and remains an absolute priority for us. I'm aware that those who are with you in the space that you're in have already given you information about what has been done in terms of cleaning and sanitizing the place where you are. And I know you'll be also aware of the careful steps that have been taken to maintain social distancing and to ensure that all proper precautions are put in place to protect you. I know also that face masks are available to you. I know that I think one of you has availed yourself of that opportunity. It's absolutely a matter for your choice. If you wish to use them during the trial, of course you may do so. But whatever your choice is, it is absolutely a matter for you. Now, one or two things to do with the trial. A good number of the things that are important are set out in the videos that you've watched and in the document that you've been given setting out your duties and responsibilities. And I'm not going to repeat them. Particularly because a lot of them are about how you should behave when you're not at court, when you've gone home at the end of the court day. But since you're here to try only one case, and that case, come what may, will finish at some point today. There's really no need for me to say anything new about all of those things. It's important, however, to mention what lies at the heart of those instructions. The decision that you are here to reach is one for you to make, the 12 of you, without any interference from anybody who's not one of your number. And also that your decision is based purely on the evidence that you've heard in court, to which you will apply your good common sense and your experiences of the world, all of which you will share with each other when the time comes for you to deliberate on your decision, when I know you will listen courteously and open-mindedly to each other. There is one obvious and important difference between this trial and the conventional jury trials that we're all used to. You will have worked it out for yourselves. Obviously, we are not all of us in the same place. That gives rise to a few topics that I think I need to mention. The first is that the trial is going to be conducted with proper formality and in accordance with proper rules and procedures. The barristers and I, as you can see, are wearing our court robes, and we're doing that entirely to underline that point, that this is a court that will adhere to, as I say, proper rules and proper procedures. And just as we are dressed as if we were in a conventional court, so also we will conduct ourselves in that way. Secondly, none of the witnesses you're going to see and hear will be in the same physical place as you or any of the rest of us, for that matter, are. Now, whilst it's unusual for all the witnesses to give evidence remotely, it has become commonplace over time for some witnesses to give evidence in that way. For example, sometimes a witness may, in some way or other, be vulnerable to the point that they may find it difficult to give their best evidence in the courtroom, the court environment, with all the additional stresses that that involves. Witnesses like this will routinely give their evidence from a location outside the courtroom. Another example, sometimes a witness may be abroad or at some distant location within the United Kingdom. And in those circumstances, these witnesses are, again, routinely allowed to appear via electronic means, rather than having to make long, expensive, and unnecessary journeys. Now, I'm not going to pretend that these changes, when they came along, were met with enthusiasm by every single lawyer. But then again, the word lawyer and the phrase eagerly embraced change are rarely, if ever, found in the same sentence. But as time has gone by, experience has shown that these procedures act to promote fairness and justice, and that evidence given in the way you're going to hear it can be and is subjected to appropriate challenge by way of cross-examination and, critically, appropriate evaluation by juries. So what we're doing here today is unusual, but only to the extent that all of the witnesses are giving evidence remotely. But the whole concept of a witness giving evidence remotely is by no means novel. You're going to see these witnesses on your screens. You will hear what they have to say. You will hear their evidence challenged and disputed, and you'll be able to evaluate their evidence just as you would if they had been in the same room as you. Now, another different topic. Sometimes a member of the jury might want to communicate with the judge. It may be as simple as a request for a short break, on which topic I should tell you that at some point, it's likely you'll have a short break while we deal with legal matters. And we've built into the timetable a 20-minute break about halfway through the trial itself. So there will be breaks for you. But you may need, for whatever reason, more urgently a short break, or it may be that you want to communicate something more complicated, a problem with hearing or understanding what a witness is saying, for example. Now, in the conventional setting, the answer to these issues is for the juror to write it down on a piece of paper, which will then be brought by the usher to the judge. But that isn't going to be possible here. I know where you are. I know, I'm not going to tell you where I am, but I promise you it's a very long walk from where you are to where I am. So the handing of a bit of paper is not going to work. But the answer is there for you. It's the chat function. You're aware of that. I think you've had instructions. If you don't know what I'm talking about, shake your heads, but you understand that. Please use it to communicate directly and privately with me. I'll keep an eye on it. I've actually got two computers running, one watching the trial and the other to my right, which has got the chat function on it. But I won't necessarily see it. I'll try and keep an eye on it, but I won't necessarily see it. So you'll know if I have, because I'll stop the proceedings and deal with it there and then. And you'll therefore know if I haven't seen it, because I won't stop the proceedings. And in those circumstances, please feel free to raise your hand and wave it about, and I will then understand that there is a problem and get it sorted. That's really all I want to say to you at this stage. The trial is about to start. This is my fault. I have leapt in too quickly to say what I'm now saying to you. There's a formal process that needs to be done. It will be done now, which is you are formally put, as it's called, in charge of the defendant, or the defendant put in your charge. This is the way in which you are, as it were, appointed to be the jury. So I'll ask that that is done by the court clerk, as it now will be. And when that is done, Mr. Trafford, who prosecutes the case, will tell you what the prosecution say it's all about.
Members of the jury, George Drew stands charged on this indictment with one count of unlawful wounding. The particulars of the offence are that on the 21st day of June 2019, he unlawfully and maliciously wounded Joseph Black. To this indictment, he has pleaded not guilty. And it is your charge to say, having heard all of the evidence, whether he is guilty or not.
Thank you very much indeed. Mr. Trafford.
Your Honour, thank you very much. Members of the jury, just look at you as I am now. Can I just confirm that you can all hear me? I'm going to have a quick skirt and look at you and everything seems to be fine. Members of the jury, I'm prosecuting this case, which means I'm acting on behalf of the Crown, and helpfully enough, of course, I have the name underneath me of prosecution. If you look slightly to the right of your screen, you'll see my learned friend Miss Oakley, who has a Nonica defence under her. She is defending this defendant throughout the course of this trial. Members of the jury, you heard one moment ago the learned clerk putting you what was called in charge, and she read out what we call the indictment to you, which this defendant faces. And this is our first technical thing together, if I may. You should have what's called a jury bundle with you. And I think, in fact, you access that through a second screen that you've got. So can we just very briefly, please confirm that you and I have the same information. You have the jury bundle on your screen. And I'm going to ask the indictments to be brought up, which is page 1. I see some heads nodding. Does everyone have the indictment on their screen? That's excellent. There is, in fact, members of the jury, this will be the jury bundle that will be used. It's fairly short. It's, I think, about 8 or 9 pages, something like that. And throughout the course of this trial, people refer to various documents. They will cite what they want to look at on the jury bundle, and that will be brought up on your screen. So I just wanted to make sure that you've got that in front of you. I won't probably be referring to anything else as I open this case to you, but this, of course, is the critical document, because this document is, members of a jury, why you are here. The defendant, as you know, facing this count of unlawful wounding. I'll come to the law in relation to that a little later on in my address to you. So, members of the jury, what is this case all about? Well, let me tell you. About a year ago, on the evening of the 21st of June, a young man, Joseph Black, decided to do something that people have done until very recently, uninterrupted for many decades, if not hundreds of years. He decided to go for a drink in a pub. He was a regular member of a jury at a pub called the Queen's Arms, and there he went and met up with his friends when he arrived. It was about 7 or 7:30 in the evening, and it was a clear, pleasant summer's evening. Neither he nor anybody in that pub could possibly have imagined the violence that was about to take place. Now, Joseph Black, members of a jury, was a smoker. And like all smokers now, he was obliged to go outside on occasion when he wanted to have a cigarette. And a couple of hours into his evening in the pub, that is exactly what he did. It was still light, and he went outside on his own, in fact, for a smoke. But another man then turned up, followed him, perhaps from the pub. He was, we say, the prosecution says, this defendant, George Drew. He was, when he was coming out of the pub, already loud, and he was acting very aggressively. He started immediately having a go at poor Joe Black. He was accusing him of various things, for example, about being mouthy. Joe Black, sensibly, he might have thought, and you may well think, said nothing in response. He just smiled, and members of the jury, he turned the other way. Unfortunately, in turning the other way, Mr. Black left himself exposed. And the defendant, entirely unprovoked, you may think, members of the jury, lunged at him with his beer glass, which smashed on the face, on the left cheek of Joe Black, and slashed his face from his ear down to his jawline. And as you will hear, and as you will see, from evidence that has been agreed, that is the injury that was caused, and that is the subject of the wound on this indictment that you looked at a moment ago. Now, the defendant, having attacked Mr. Black in this way, simply then went back into the pub. And Mr. Black, of course, was bleeding very heavily, and he returned into the pub, where he was given help by his friends and colleagues and regulars there. As you would expect, the police and the ambulance turned up. And as Mr. Black left with the medics to go to the ambulance, he saw the man, he saw this defendant who had glassed him, if you'll excuse that expression. He had never seen or met this man before, members of the jury, but he saw him when he was coming out of the pub with that injury to his face, getting into the ambulance, and he immediately pointed Mr. Drew, the defendant, out to the police who were in attendance. Mr. Black was then put into the ambulance, and he was then taken away to hospital. Now, this is in fact not the end of the evidence of that awful attack that night, although you might think that on its own that is quite enough. There was in fact a man walking his dog on the opposite side of the road to the pub, unbeknown, one suspects, to the defendant and Mr. Black. When the attack took place, he was on the other side of the road to the pub, walking past a petrol station. At some stage, members of the jury, you'll see pictures of both the petrol station and indeed the pub. And he saw from that petrol station at that time precisely that which I have described to you. He saw a man shouting at another man who turned away and was then glassed. This witness, Lee Wilson is his name, and I read it out to you earlier, in fact knew who the attacker was. He knew the defendant. He knew George Drew. And when later on he had heard what had happened that night, he reported what he knew and what he had seen to the police. And of course, as I've already said and you've already heard, you'll be hearing from him giving evidence in the course of his trial. The defendant himself was taken by the police straight to the police station that night from the pub, and he was interviewed. He had the benefit of a lawyer, a solicitor with him. He gave, through his lawyer, in fact, a written statement in which he very clearly denied that he was anything to do with this attack. He said, members of the jury, that he never left the pub that evening until Mr. Black came in covered in blood. He left, he said, because he hated the sight of blood. Otherwise, members of the jury, he said he had not left the pub at all that evening. Now, a couple of days after this incident, on the 23rd of June, in fact, a broken beer glass was found underneath a little signboard just outside the pub, which was very close to where the two men had been standing that night and where that assault took place. That beer glass was sent away for analysis, and you will hear, and it is agreed, members of the jury, that it was found to have the fingerprints of this defendant on that smashed beer glass that was found outside of the pub where this assault took place. There is, members of the jury, I regret to say, no CCTV available to you or to the court or anybody else that covers the areas around the pub or the petrol station, I'm afraid, on that particular night. A week or so after the incident, Mr. Black himself, the victim of this attack, attended an identification procedure. And he was there shown a number of photos of 8 similar-looking men. And members of the jury, on that day, on the 28th of June, 1 week after the attack, he identified this defendant as his assailant. Now, members of the jury, this is, of course, the barest outline of the facts of the case and what leads you to be here today. The defendant is now charged, as you have heard, with unlawful wounding. Now, that is to say, without any lawful justification and intending to do some physical harm, he caused a wound to Joe Black. Now, members of the jury, that moves me to this, of course. That is what is called a matter of law. And law is certainly not for me, and it's not for you. This is a matter entirely for the judge, and any directions of the law you must take entirely from him. Now, members of the jury, evidence about what happened that night, evidence about that charge, is in fact not what I've just said to you in opening. I'm just giving you, as I've said, a bare outline. The evidence is what you hear from witnesses on your screens and what is read to you, or in fact, in this case, as much of it, what is formally agreed between the parties, that's to say, between the prosecution and the defence. The purpose of this opening is merely to set the scene. But it has another purpose, of course it does. This is to tell you that it's the prosecution, it's the Crown, it's me that have to prove this case and prove this case to a high standard. That standard being one where once you have returned to consider this evidence and are in your room deliberating as you will be, you have to be sure, members of the jury, that's the important word, sure of your verdicts. Now, so whilst this trial may be relatively brief, and whilst this trial is certainly one that is a new, and it might be said by some, a groundbreaking procedure to conduct trials, of course, the way we're going to assess evidence, the way we present evidence is precisely the same way that it's done in normal courts. And without more, and perhaps with His Honour's leave, I will call in fact my first witness, Joseph Black.
Very well, thank you.
Would you like to take an oath or to affirm, please?
I think he needs to turn on it.
Mr. Black, can you hear? Can you hear? Just raise your hand if you can hear. Okay, I think you're muted. Can you unmute yourself?
I should be unmuted.
Yeah, we can hear you now. Thank you.
Okay.
Would you like to take an oath or to affirm, please?
To affirm, please.
Right. If you'd like to repeat after me.
Yeah.
I do solemnly.
I do solemnly.
Sincerely and truly.
Sincerely and truly.
Declare and affirm.
Declare and affirm.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you.
Now, Mr. Black, sorry, I interrupted you. I'm so sorry. Before we start on your evidence, it's important that you fully understand that although you're in your own individual space, you are actually giving evidence in a formal court of law. You understand that, I hope?
Yeah.
And that we will apply all the proper rules and procedures, and the obligation on you, as with any witness in any circumstances, is of course to abide by the affirmation that you've given.
Yeah.
Good. Thank you. I'm sorry to have to say these things to you, but you understand the importance of it, I'm sure. The other question I have to ask you is, can you reassure us all that you are on your own without anybody there to assist you or prompt you in any way?
Yes, I am on my own in this room.
Okay. You never know, I might ask you to put your device through 360 degrees to prove that.
Yeah.
That's, I gauge from your reaction, you are not troubled by that. No. So I won't require you to do it at the moment. Okay, you'll now be asked some questions.
Your Honour, thank you very much. Could you give your full name to the court and the jury, please?
Yeah, my full name is Joseph Black.
Thank you very much, Mr. Black. I'm going to ask you some questions about events that took place roughly this time last year, on the 21st of June 2019. All right?
Yeah.
Now, I may pause on occasion. I'm not being rude. People may be taking notes, matters such as that, all right?
Right.
Now, can I begin with this? I think on that evening, you decided to go out for a drink. Is that right?
Yes, I went down to the Queen's Arms, and it was around 7 o'clock.
Thank you. Is that your local, Mr. Black?
Yeah.
That is?
That is, yes.
Thank you very much. And were you expecting to meet any friends or any other people that you knew when you were there?
I went to the pub alone, but I was expecting to meet other regulars there.
Thank you very much. Was there a decent crowd there that night? Was it fairly full?
Yes, as the evening wore on, it did become quite crowded.
And Mr. Black, did you meet people that you knew in the pub, and did you have drinks with them?
Yeah, I did meet other regulars in the pub. We sat down and we had drinks.
Thank you. Mr. Black, I think it's one of those, it's a no-smoking pub, is that right?
It is a no-smoking pub, yes. I had to go out to have a smoke.
So you're a smoker, yeah? And is it
yes,
right
I am.
Have a cigarette?
Yeah, I did go out to have a cigarette.
Thank you very much. Can I now perhaps ask you to look at some photographs that are in what we call the jury bundle? And this should, I think, come up on your screen. So what I'm going to ask for, please, is for you and the jury to look at page 5. It's a photograph taken, in fact, of the Queen's Arms. So I'm going to look at the jury and I'm going to look at you to check that everyone's got it.
Right.
And I think I see some nodding. Do you have it yourself, Mr. Black?
Not yet, just a moment.
Thank you.
Yeah, I'm on page 5.
Thank you. And that should be, I hope that you've got what I've got and not the jury's got and whatever else has got, which is a picture of the Queen's Arms public house.
Yeah.
Is that right? So when you come out for a cigarette, where do you go and have your smoke when you leave the Queen's Arms? Just looking at that photograph.
So upon leaving the Queen's Arms, I went around the side, just behind where you see the sign there. I was in between the sign and the pub.
Right, so we see it's a little bit blurry on my photograph, and that's my fault, I'm sure, on my glasses. There's what appears to be a small tree. Is that the sign to which you refer?
Yeah.
And that sort of comes out of the sign? Yeah?
Yeah.
So it's about there that people go, and you went that night for a cigarette?
Yeah, that's where I went that night.
Thank you very much. I don't need to look at that photograph again for a moment, so you can, if you like, put that down.
Yeah.
Now, when you went out for a smoke, Mr. Black, did you go on your own?
I did go on my own, yes.
And when you went out there, did you see anybody else?
Initially, I was alone until the man who glassed me came out. That was whilst I was in the middle of smoking.
All right. Well, I'm going to ask you a couple of questions about that, if I may, Mr. Black. So you went outside for a smoking and standing by near that sign and that little tree, and you say somebody else came out. Can you describe that person?
I can't describe them exactly, no. It was only for a moment. I did pick up on small details, but I'm not in a place to describe it in depth.
What were those small details, Mr. Black?
Well, his clothing was what particularly struck out to me. He was wearing denim jeans, and he was wearing a short-sleeved either T-shirt or summer shirt, one of the two.
Did when he came out, did he talk to you? Did he come up to you? Did he do anything like that?
So I was in the middle of smoking, as I already said. He approached and then claimed that I was being mouthy against him whilst I was in the pub. I laughed this off because it was untrue. Upon laughing, I turned away from him, and that is when he lunged at me with his glass, which smashed against my cheek.
So just to break that down very, very briefly, please, he made some allegations against you about what had happened in the pub. Is that right?
Yes, he claimed I had been mouthy against him.
Do you remember seeing him at all in the pub?
I don't remember seeing him, no.
And so, did you engage them at all? Did you speak to him at all?
No, I didn't speak to him. I simply laughed it off. I assumed it was a case of mistaken identity, that he thought I was somebody else.
And you say you turned away?
I turned away, yes.
Now, as you turned away, tell us, or tell the jury, tell the court what happened as you turned away from him and having laughed off his allegations.
So I turned away, and upon that point, I felt his fist with a beer glass in it smash against my face. And then for a few moments, I was overtaken by overwhelming pain.
Yeah. Do you know what happened to him after he did that? Did you see him go anywhere? Did he stay where he was? Did he go away? What happened?
Yeah, I did notice he walked in the direction of the Queen's Arms. It seemed to me like he was wanting to re-enter the pub.
Yeah. And what about you, Mr. Black? What did you do?
Well, it took me a few moments to regather my senses. Once I did that, I walked back into the pub to get some assistance.
And did people help you when you got in there?
Yeah, upon going in there, I was helped.
Yeah. I think it's been agreed that the police and ambulance, in fact, arrived quite soon afterwards. Is that right?
They did, yes.
And I think some of the medics on the ambulance helped you outside, leave the pub and go outside to the ambulance. Is that right?
They did, yes.
Now, did anything happen outside? Did you see anyone outside as you were leaving the pub?
When I was outside, I noticed the man who glassed me. He was wearing the same attire, and I pointed him out to the police.
And when you saw him outside, as you were getting into the ambulance, how far away from you was he when you saw him again?
When I pointed him out to the police.
Yeah, do you know how far away he was from you when you pointed him out?
He was quite close, I'd say within a few meters.
Within a few meters. And in terms of conditions that night, 21st of June. Was it light? Was it warm? Was it clear?
It was light, yeah. As most of you will know, it was the summer solstice, the longest day of the year, and the sun was still out at that time, so I could see clearly.
Yeah. I think you were then taken to the hospital. Is that right?
Yeah, I was then taken to the hospital.
And you received eight stitches. I think this has been agreed to the side of your face.
Yeah.
And in fact, I've got a mock-up, if you like, of the injury you received. It's at page 3 of that jury bundle. It's obviously not a photograph of you, Mr. Black, but it's a representation of that. Can I just look at the jury to see they've got that page 3? I see this nodding. Mr. Black, you may not need to look at it, but if you can, that would be great. You can see there on that mock-up a jagged scar marked O1 going down from your ear to, I suppose, halfway down your jaw or something like that.
Yeah.
And is that the injury you received from the person you identified that night?
That is the injury, yes. And by that person I identified.
And help me with this. Had you ever seen or spoken to or engaged with that person before he came out and attacked you that evening?
Not to my recollection, no. To me, it was an unprovoked attack.
All right, thank you very much. I think one last matter. I think you were asked to attend the police station about a week later on the 28th of June.
Yeah, I was.
An identification procedure.
Yeah.
All right, we're going to hear some agreed evidence about that, so I need not ask you in detail about it. Mr. Black, thank you very much for answering my questions. There may be some questions for you from Miss Oakley Defence Counsel.
Yeah.
Yes, exactly.
Mr. Black, you arrived then at the Queen's Arms, I think you said at about 7 o'clock, is that right?
About 7 o'clock, yeah.
And you went outside for a cigarette at about 9:30.
About 9:30, yes.
So over a period of about 2.5 hours, you had spent time with your friends inside the Queen's Arms?
Yeah, I was in the pub with my friends in the intermediate time from 7 to 9:30.
And during that time, did you consume any alcohol?
I did consume a few pints of beer.
And when you say a few pints, can you help us as to how many?
Yes, it was about 2 or 3.
Can you remember how you felt after drinking those pints of beer?
I was very slightly tipsy, but within my senses. I was walking just fine and could comprehend all that was around me as I went out the pub and around the corner for the smoke.
So would it be fair to say that you were beginning to feel the effects of the alcohol you'd consumed?
I was beginning to feel the effects, but only very slightly, yes.
And when you went outside, you were on your own?
Yes, I was on my own.
And the pub is somewhere that you've been before, and it's located, isn't it, on a road called Borough Road that we've seen in the photographs?
Yeah.
Apart from the person that you say attacked you, do you remember seeing anybody else at all?
No.
Did you see anybody, for example, immediately outside the pub?
Not to my recollection.
Or walking along the road?
No.
So you had just gone out on your own, in effect, for a quiet cigarette?
Yes.
And would it be fair to say that what then happened was completely unexpected?
Yes, completely unexpected.
There was no warning whatsoever, was there?
No warning, apart from the preceding words, when he claimed I'd been mouthy to him.
The first you were aware of any trouble was when this man appeared suddenly in your face, wasn't it?
Yeah.
And the first time that you saw him, he was, as I described it, in your face, wasn't he?
He was close, yes.
And he was angry and he was shouting.
He was.
And your response to that was to immediately turn away.
Yeah, I laughed and turned away.
And you spoke a moment ago, having turned away and having been struck with the glass, as being overtaken by an overwhelming pain. You were stunned, weren't you?
Not quite stunned, but I was, for a few moments, yes, sort of knelt over, coming to grips with what had happened to me, which was the glassing on the side of my face.
And would it be fair to say then that everything happened fairly quickly? I think you described it in a moment.
Yeah, it was quick.
And it was also, would you accept then, a very fast-moving incident?
Yeah, I mean, after he glassed me, he walked away. But I did get a chance to see him and where he was going, as I said earlier.
And that opportunity to see him walking away, you would no doubt have seen the back of him.
Yeah, so that's why I remember his clothes so vividly.
In terms of the incident, would you agree, fairly shocking to you?
Yeah, it's not happened to me before.
And as far as the man himself is concerned, you, as you said to us a moment ago, are not able to describe him in detail.
I can't describe his face in great detail, no. But upon seeing him, I instinctually felt, yes, that was him. And the clothing matched up too.
I think you said that when you saw a man later on, you identified him because he was wearing the same attire.
The same attire, yes, exactly the same.
And you had never seen this man before?
No.
And would you accept, in light of what you have described and how fast this incident happened, that you didn't get a particularly good look at his face?
Not an excellent look, no, it was brief. It was brief.
And can you help us with this? When you felt that fist in your face with the glass, was it the fist, a right-handed fist, a fist of a right hand?
I actually can't remember whether it was right hand or left. I was looking away, as I said, when the strike was made against my cheek.
The injury's to your left cheek, is that right?
The injury is, yes, to my left cheek.
And after you had been glassed, you made your way back into the Queen's Arms pub.
I did, yeah.
And I think you told the police that you didn't see precisely where that man had gone after he glassed you.
Not precisely, but it seemed to me he was making his way back to the pub.
And the last time you actually saw him then, he would have been outside the pub.
The last time that I saw him, yes. He was walking towards the pub. He was on the outside. He will have, yeah.
And we've heard that the police and an ambulance subsequently attended, and that when you came out, you saw a man standing outside the pub, didn't you?
I did, yeah, and I immediately knew that was the same man.
Because you saw that the man was wearing the same attire.
The same attire, yes, and
can I... forgive me, can I ask you, the attire that you recognised, what was that, please?
Blue denim jeans and a short sleeve, either t-shirt or summer shirt.
Was there anything distinctive about either of those items of clothing?
Not particularly.
When you saw that man outside the pub, was that in the same area that you had seen the man last walk away from you after he glassed you?
Yeah, so after he glassed me, he was walking around. When I saw him again, when the police had come, he was close to the entrance. So it was a bit further away, 2 or 3 steps maybe.
Do you think that it's possible that you identified that man instinctively because he was in the same location as you'd seen the man when he walked away?
It was instinctive, but it was based on what I saw, which was his attire. And also, upon his appearance, I felt it was the same man.
And the appearance that you rely on was a man wearing denim jeans and possibly a short-sleeved top.
Yeah.
And when you attended the police station on the 28th of June, you picked out an image of a man as the man you saw outside when you pointed him out to the police. Is that right?
Yeah, I remembered him exactly, and so I was able to pick him out.
Can I ask you, Mr. Black, this? What is it about the man's face that you can remember, please? Or is it, in fact, the clothing?
It is, in fact, the clothing mostly. I couldn't remember specific details about the face, but when I saw it, I just instinctively felt, yes, this is the man. And of course, the clothing supported that. He's wearing the same things as the man who glassed me.
Your Honour, I have no further questions.
Thank you.
Does Your Honour have any questions for this?
I just want to clarify one thing that I'm not absolutely clear about. Ms. Black, you've been asked a little bit about this already, but I just want to clarify it in my own mind. The jury are going to hear quite soon the exact words you used when you looked at the photographs at the identification procedure in the police station a week later.
Yeah.
And I'm going to read you the words and ask you a question about them, okay?
Okay.
The words you used were, I can positively identify man 6, the photograph of a man at number 6 in the lineup, as it were. I can positively identify man 6 as the person I pointed out to the police as I was leaving the pub that night.
Yeah.
And what I wanted to ask you about was your use of those words, the man or the person I pointed out to the police as I was leaving the pub that night. Because I don't think there's any dispute that that was the man that you picked out outside the pub.
Yeah.
But here's the question, really. What you didn't say was, as the man who glassed me outside the pub. And I wonder whether there's a distinction between the two that you would recognise. Do you understand the question?
No, there's no distinction. I understand the question. And yes, it's the same man. The man I pointed out outside of the pub is the same man who glassed me around the corner of it.
So I think the question is, I'm not challenging you, but it's something the jury may be thinking about. Why didn't you then say the man number 6 is the man who glassed me, rather than the man I picked out?
I understand. Yeah.
I wonder why you didn't say that.
I guess it was just under the pressure of the situation. I didn't think clearly about the words that I used.
Yeah.
And so that's what I used instead. Yeah. But by all means, I did mean he was the man who glassed me.
I understand that. I just wanted to clarify all of that if it needed clarification.
Yeah.
Mr. Oak, anything you want to ask arising out of that?
No, thank you.
Mr. Trafford?
No, thank you very much, Your Honour.
Okay. Mr. Black, thank you very much indeed. You're now free to go. Thank you.
Right, thank you.
I'm required to say to you, it's a bit silly in the sense that you are in your own individual place, but you mustn't talk to anybody else about your evidence in the case until the case is over. Not that I think you'll get an opportunity anyway. Okay, thanks very much indeed. We're going to shut you out of the court now and hear from somebody else, I think, Mr. Trafford. Thank you, Mr. Black.
Yeah.
Thank you.
Your Honour, thank you. I call Lee Wilson, please.
Thank you.
Would you like to take an oath or to affirm, please?
Affirm.
If you'd like to repeat after me. I do solemnly.
I do solemnly.
Sincerely and truly.
Sincerely and truly.
Declare and affirm.
Declare and affirm.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you.
Now, Mr. Wilson, before we start on your evidence, there's a couple of things I need to say to you, as I would say to any witness. It's not just you, okay? Although you're in your own private place, individual place, and not physically in a court of law, you are participating in a formal jury trial. You understand that, I hope?
Yes.
Good. And so all the rules, all the procedures that would apply in a courtroom apply to you as you sit in your own place giving your evidence. Good. I need to have a reassurance from you. Somebody's got some background noise. Mr. Drew, I suspect it may be you. Can you hear background noise in the place you're at?
There's some background noise outside, yes.
Would you mind muting yourself just so we're not distracted by it? Is that all right? Thank you very much. It's really helpful. Thank you. Mr. Wilson, it's important that you reassure me that you are on your own in your space without anybody there to prompt you or in any way to help you as you give your evidence. Are you on your own?
Yes.
Okay, well, fine. I was going to offer the challenge to you to turn your device through 360 degrees to prove that. No, don't. The fact that you're willing to do so tells me all I need to know. All right, okay, thank you. Mr. Trafford.
Thank you, Your Honour. Could you give your full name to the court, the jury, please?
Yes, it's Lee Wilson.
Thank you. Mr. Wilson, I want to ask you some questions about the evening of the 21st of June, Midsummer's Evening last year. All right?
Yes.
Can I begin in this way? What were you doing at around about 9:30 that night, please? Can you remember?
Yes, I was heading into the town centre for a date.
I see. And were you with anyone or anything?
No, I was on my own.
Thank you. Did there come an occasion when you were walking towards the centre that you passed the SO garage?
There did, yes. I had to walk past that on the way to town.
Forgive me, I cut across your answer. Do say it again.
I was just saying I walked past it on the way into town.
Thank you. I'm going to ask you to look, if I may, please, Mr. Wilson, at a couple of photographs before I ask some more questions, just to confirm that you've got them. There are photographs 4 and photographs 5 in what we call the jury bundle, which you should have to hand.
Yes, I think I've got those.
If you just open the first one up, please. It's photograph 4. Can I, again, in the usual way, just look very briefly at the jury's faces and see they've got it and they can nod? Yep, everyone seems to have it. Thank you very much. So can we look at photograph 4 together, Mr. Wilson?
Yes, I have that.
Seems rather obvious, doesn't it? But that's a picture of the Esso petrol station to which you referred. Is that right?
That's correct, yes.
And that, in fact, is on the opposite side of the road, isn't it? That is the view that you've had if you were at the front door of the Queen's Arms Public House, isn't it?
That's correct, yes.
And so if we go over the page, if that's the right expression, on a computer to page 5, we'll see, if you like, the reverse view.
Yes, that's the Queen's Arms Pub.
Thank you very much. And that's the view you have, is it, from the petrol station? That's the view you had that night?
Yeah, pretty much, yeah.
Thank you very much. So I'm just going along. Did anything, when you were walking towards the town, towards the pub and petrol station, did anything attract your attention outside the pub that night?
Yeah, there was quite a lot of shouting as I was walking past the Esso station.
All right. Did that cause you to look across the road?
Yeah, it did, because it was a bit of a ruckus.
And tell us, please, in your own words, of course, what you saw.
So I was walking past the Esso station, I looked across, and I saw one guy shouting at another guy who didn't seem to be that interested in listening to the first guy. So he sort of turned his back on him, and then the first man, when he had his back turned, hit him with a glass.
Thank you. So can I, when we go through those questions again, can you just have a quick look at photograph 5, please, and have that up in front of you, if you would?
Yep.
All right. So was that the view you had of this incident?
Yes.
Thank you. And where can you identify, just describing it, where the people were who you talked about a moment ago?
They're at the front, sort of near the car park side, that front corner that we can see in the photograph nearest to us.
Right. So
yeah, after they argued, both people went back in through the front door of the pub.
Right. So just break that down a bit. We can see a car obviously through a gate. We can see a sign with what looks like a tree coming out of the top of it. Mm-hmm. Was it about there or?
Around there, yeah, near that sort of that front corner with the black stonework.
All right. Thank you very much. So you saw one person shouting at another. Is that right?
Yes.
Did the person to whom that person was shouting respond at all?
No, they just turned away.
Turned away. And then please just again describe, if you will, what you then saw, that person having turned away, what the first person did.
Hit him in the side of the head with a pint glass, I think.
Pint glass, you think. All right. And was it once, or did it continue, or did it immediately stop?
It was once.
Right. And what did that person do? That is to say, the person who struck the person with the pint glass, what did he do afterwards?
He immediately sort of quickly walked straight back into the pub.
And did you, in fact, see him go back into the pub?
Yes.
And could you help us with what the other person did?
The other person was sort of bleeding quite heavily at that point, and they also went straight back into the pub pretty soon after.
Thank you. Two people, haven't we, Mr. Wilson? Did you know either of them?
Yeah, I knew the man who hit the other guy.
So you knew the assailant, the person who did the assault, is that right?
Yes, that's correct.
And what was his name, please?
It's George Drew.
And how long, please, Mr. Wilson, have you known him?
Oh, I don't know exactly. Years and years.
Years and years. And did you have any difficulty in recognising him?
Nah, I've seen him around loads. I knew who it was straight away.
Right. And at some stage later, I think you, and it was agreed, you reported this matter to the police and what you knew.
Yes, I did, yeah.
Mr. Wilson, thank you very much. I've got no further questions for you.
Thanks, Mr. Trafford. Yes, Miss Oakley, thank you.
Miss Oakley is on.
You're muted, Miss Oakley.
Apologies.
Not at all. It's easily done.
Your Honour, before I cross-examine, there's a matter of law I may wish to raise.
Right. Okay. These always take a little time, I know, even if they're not controversial. Members of the jury, I'll deal with this as judges all. I'm hearing myself twice. Am I the only one? Anyway, members of the jury, that's better. It's not better. Never mind. I'm going to deal with this in your absence, because that's what always happens when legal matters arise. But it gives you a chance to have a break. My laptop. Somebody's fiddling with paper. Could they please mute themselves before they do that? My laptop says 11:27. I'll call it 11:28. And could you be back for 11:38? Gives you a chance, subject to social distancing and safety and so forth, just to stretch your legs, get some fresh air or whatever. Is that okay? 11:38, we'll start again. Good. Okay, I'm going to shut you out, and I'm going to hear what the legal argument is. Good. Now, basically, Mr. Wilson, I'm going to have to ask you also to shut yourself out of this by being shut out of the discussion.
Okay, I'll do that now.
Well, it'll have to be done by the technicians, not by you, I think. Yeah, good. Okay. Exactly. Thank you. You've helpfully sent me, and Mr. Trafford, I think, has had it, a skeleton argument, or at least an indication as to the nature of your application. And as I understand it, you better tell me in your own words what it is.
There's an application to reduce the bad character evidence of Mr. Wilson, and in particular, one conviction recorded against him for an assault on Mr. Drew in 2016. It's that one single matter. The application is made pursuant to Section 101B of the Criminal Justice Act of 2003. Can I, from the outset, apologise that the application wasn't lodged before?
Well, you've explained the late service. I needn't trouble you with that. It's
I'm very grateful.
The substance of the application.
The defence seek to reduce the conviction of the assault and submit that it is substantial probative value in relation to the credibility of Mr. Wilson, which is a matter in issue and a matter for this jury to consider. May I make it absolutely clear that I don't rely on the particular circumstances of the conviction, but I do rely on the fact of it for this reason. It is submitted that that conviction provides this witness with a motive to lie about what it was that he saw, and most importantly, who he saw outside the Queen's Arms pub in June of 2019. We submit that as a result of that assault, he bears a grudge against Mr. Drew, and therefore the evidence is of substantial probative value in the context of this case and ought properly to be admitted.
So you may want to make a submission about whether his identification is reliable or not, but leaving that to one side, your principal attack on him, if that's the right way of putting it, is that he has maliciously invented his account to implicate your client in a crime he did not commit in order to have vengeance against him for some slight occasion to him in the past.
Yes.
Yeah, I see. Mr. Trafford?
Well, Your Honour well knows it's regrettable that an important matter such as this was not notified to the prosecution before, in fact, 3 minutes before we started this trial. Nonetheless, I'm grateful for the written application I've now received. It's clearly we do agree, relevant if we had had time perhaps before this matter to discuss at the point we could have narrowed the ambit of it, but we do agree that the conviction itself is clearly relevant to the cross-examination of this case, and it's therefore in fact admissible. But one relies on my learned friend's experience of these matters to keep matters in a fairly narrow focus when she uses these pieces of information.
Yeah, okay. Just to defend Miss Oakley's reputation, the email to which the application was attached was 26 minutes before the trial started, not 3. But it was quite late nonetheless.
Right. Perhaps I keep in preparation. Forgive me for an inaccurate time. Very short.
Or you're no good at reading your emails, one or the other. Okay, but thank you very much indeed. Okay, Miss Oakley, I will permit you to leave that evidence for that limited purpose.
Thank you.
You will understand the limitations on it. Indeed, you've acknowledged that yourself. I'm sure I won't have to intervene to restrain you.
No.
Okay, well, thanks very much. No, I'm sure I won't. Sorry, that was a sort of unnecessary veiled threat. I withdraw it with apology. Okay, I gave the jury 10 minutes for what was going to take 5, just to give them a chance to stretch their legs. We have that same opportunity, but only for 4 or 5. I shall leave court now, but I shall re-enter court willy-nilly at 11:38. I'll see you all then.
Oh, really? Stay there. Stay there. Stay there.
Good. Well, I have, as you can see, returned to court. We need the defendant, and we need the witness, and of course the jury. Mr. Drew, Mr. Drew, just to clarify, I asked you to mute yourself because of the background noise at your end. You do understand that if you need to intervene, you're limited to unmute and to speak if you have to. Good. It's not to shut you out. It's just to make life less distracting for us. That's all. Good. Thank you. Good. Good. We're all here, I think. Ms. Oakley, you'll have some questions, I think. Muted. You're muted again.
Can you hear me now?
Yeah, that's good. Yeah.
I think I'd been muted by the controller.
Oh, have you? Oh, okay, all right. Good. Well, we got you back now, so on we go. Thank you.
Mr. Wilson, you made a statement to the police on the 3rd of July last year, didn't you?
Yes.
And that was the first time that you had told the police that you had witnessed an incident outside the Queen's Arms pub on the 21st of June.
Yeah, that's correct. I was pretty certain that he was going to get reported to the police anyway when he'd gone back in the pub.
Mr. Wilson, it would help if you just answer the questions that you're asked. Don't anticipate the next one.
Okay.
So 12 days had passed before you spoke to the police. Is that right?
Yeah.
The 3rd of July wasn't the first time you could have spoken to them, was it?
No, it wasn't.
You could have spoken to the police on the 21st of June, couldn't you?
Yeah, I could, yeah.
Or in fact, any day thereafter.
Yeah.
But you didn't, did you?
No.
You made a conscious and deliberate decision then not to.
Yeah.
And in fact, you only spoke to the police when I think you'd said you heard that Mr. Drew had been released without charge.
Yeah, that's correct.
Who was it that you were speaking to, please, about the incident on the 21st of June?
I didn't speak to anyone about the incident.
What was it that you heard and who from?
Oh, I just heard that he'd been released from prison. I can't remember who from, but just that he'd been released on bail, and that I kind of figured at that point I probably needed to give some information to the police.
Well, who was it that you heard that from?
I genuinely don't remember, I'm afraid.
Well, what was it that you were talking to that person about?
I don't know, it just sort of came up in conversation. I think people generally know that I know the defendant quite well.
And in that conversation, were you or did you have a conversation about what had happened?
Not specifically, no, but just that he had been released on bail. I said I thought I saw something and decided I probably should contact the police.
Not only did you not speak to the police on the 21st of June, but on that night, you didn't cross the road and approach the man who'd been glassed, did you?
No.
To make sure that he was okay?
No, he'd already gone back in the pub.
Well, you said a moment ago that you also saw the man who glassed him go back into the pub, is that right?
Yes.
Well, did you not think to go after him to make sure he was okay?
Well, I kind of figured the people in the pub would look after him, and I was running late for my date.
Could you, from where you were, see who was in the pub?
No, I couldn't, no.
Or what was happening inside?
No.
You had no way of knowing he was going to be looked after at all, did you?
Not specifically, no.
But you didn't at that time go and make sure he was okay?
No, I didn't. I figured he's going into the pub. There's someone in there that's going to do something for him.
Did you think about speaking to anybody else that night about what you had seen?
Well, I did think about sort of contacting the police, but I figured there's going to be people in there that are going to call the police and look after the guy.
So you kept it to yourself?
Yes.
Didn't say a word to anyone?
No.
Didn't choose to help him or make sure he was okay?
No.
You said you were running late for your date. It wouldn't have taken, would it, more than a couple of minutes to make yourself known?
I have no idea.
Well,
could have taken a while, I suppose.
Did you think it might be worth trying to help him, to let him know that you'd witnessed his attack?
Not at the time, no.
The man that you saw, please, attacking with a glass, what was he wearing?
Oh, I don't remember, to be honest. It's quite a while ago.
Well, let's break it down. Help us, please, with what type of footwear was he wearing?
I don't know.
Can you remember the colour?
No, I can't, no.
Can you remember what he was wearing on the lower half of his body in terms of his lower clothing? Was it trousers? Was it shorts?
I don't remember.
Can you remember the colour?
No.
Do you remember what he was wearing on his top half?
No, I don't.
Do you remember if it was a shirt or a T-shirt?
No, I'm afraid I don't.
Do you remember what colour it was?
No.
Mr. Wilson, why not? Why can't you help us with these details if you say you saw this man?
Well, it was quite a long time ago and I was walking past. I genuinely don't remember what he was wearing.
Mr. Drew is somebody that you know, don't you?
Yeah, I know him really well.
You've known him since at least 2016.
Yeah, it's a good few years.
And the reason why you've known him since 2016 is because in 2016, you were convicted in the magistrates' courts, weren't you, of unlawfully assaulting him with a weapon?
Wrongly convicted. Definitely not my fault.
And as a punishment, you were required to complete unpaid work.
Yeah, and lost my job.
Exactly. You lost your job as well, didn't you?
Yes.
And the person that you hold responsible for that is Mr. Drew, isn't it?
I mean, it's not quite like that.
Well, you think you were wrongly convicted, you just said.
Yeah, definitely.
You blame him for you losing your job, don't you?
Yeah, probably.
And you still blame him for that 3, nearly 4 years later, don't you?
I mean, wouldn't you?
You haven't forgotten what happened, have you?
No, I haven't.
Would it be fair to say that as a result of that conviction and you losing your job, you hold a grudge against him, don't you?
I wouldn't call it a grudge. I don't like him.
And your identification of Mr. Drew being the man with the glass is payback, isn't it?
No, it's not. He was just the man with the glass.
It's your chance to get back at him because you feel you were wrongly convicted in 2016.
No, that's not how it is.
And the reason you can't describe what the man was wearing is because you simply didn't see him on that night.
That's because it was a long time ago. I don't remember.
And I have no further questions.
Yeah, thank you.
Paper moving, it may not be. Yeah. Just give me 1 minute, Wilson. Forgive me, please.
Yes.
Wilson, it's been suggested you wrongly identified this defendant as being the assailant that night. Can I just take you back to your evidence in relation to when you first saw this incident? You described a man shouting at another man.
Yeah.
When you initially answered questions of me. Do you remember?
Yes, I do, yeah.
When was it in that incident that you first thought to yourself, that's George Drew?
Immediately. I recognised him immediately.
And once you recognised him, did you then reflect upon what he was wearing in any way?
No, not particularly.
No. Thank you. Does Your Honour have any questions?
Yeah, just this, if I may, Mr. Wilson. It just kind of, I've got it kind of stuck in my mind a bit, and if I have, then maybe others have too. So I want to give you a chance to deal with it. What I'm thinking is that on the night, if you were there and you saw what you say you saw, there were two things you could do, weren't there? One was to go straight across and help the man who'd been glassed. That's one thing you could have done, isn't it? You're nodding.
Mm-hmm.
Do you agree with that?
Yeah. Yes, sorry, yeah.
Yeah, that's okay, don't worry. And the other thing you could have done was to have gone over and said, I know who did that. I can tell you who did it. That's right, isn't it?
Yes.
But you didn't do either of those things.
No, like I said, he was going back in the pub, and so was the injured guy. I figured.
I know that, but is that? But why didn't you?
I kind of figured that
more urgent in your life than helping an injured man or identifying a violent assailant.
Well, like I said,
see how that's kind of troubling me and might trouble others. What do you say about it?
Well, like I said, I was already running late to get into town, and I figured if he's going into the pub, someone will help the injured guy. And I've seen that the pub owners or landlord would report the incident to the police. I couldn't see what I could add to that at the time.
I see. Yeah. Okay. Well, that's a helpful answer. Thank you. So, Strafford, anything you want to ask arising from that, please?
No, thank you.
Okay. Mr. Wilson, thank you very much indeed. That's your evidence complete, and we're now going to shut you out. But thank you very much for coming. Thank you.
Thank you.
Your Honour, thank you. I have no more live witnesses. We're now moving to that stage of the case where I'm going to read some agreed facts first, and then a summary of the interview to the jury. I don't know if Your Honour wishes to address them on that at this stage, or shall I just go straight ahead?
No, I'll say something very briefly about it.
Thank you.
Members, you're going to be shown in a minute. They're on the file that you got, I think, a number of admissions and a summary and full quotation in part from the police interview that was conducted with the defendant. You're going to get this in documentary form rather than hearing evidence about it, because none of this is in dispute. And this is a much quicker and much more efficient way for you to receive evidence than to have a lot of witnesses called to speak to these things. These are all agreed by the defence to be accurate assertions of fact and an accurate summary and quotation from the police interview. So it's agreed evidence to that extent. Mr. Trafford will now take you to them and read them out to you.
It identifies I do in fact need to read them into the court record.
That's why I just said what I said. Yeah.
First document I'm going to thank you. The first document I'm going to deal with, please, is at page 6, which is the admissions document. And the usual question from me, just very brief, looking at you, as long as you've all got it up. If you could sort of nod, that would be great. Thank you. I see you have. So these are the admissions. The first admission, the photographs in the jury bundle were taken on the 24th of June 2019. The distance from the midpoint of the Esso Tesco Express to the corner of the Queen's Arms is 45 metres. Second admission, Joseph Black suffered a jagged wound to the left side of his face, which ran from just below his left earlobe to the point of his jaw. He was treated in the A&E accident emergency on the evening of the 21st of June 2019, and the wound was stitched with 8 sutures. And if I can just pause there and remind you, we have a representative diagram of that wound, which you have seen at page 3. Third, the defendant was arrested outside the Queen's Arms immediately after he was pointed out by Joseph Black. He was cautioned and replied, "This is rubbish. I never laid a finger on him." He was later interviewed. He had been offered the opportunity to have legal advice and elected to have a solicitor for that purpose. At the beginning of the interview, he handed over a written statement and thereafter exercised his right not to answer further questions. He was released from the police station at about 2 a.m. on the 22nd of June 2019 without charge. The police thereafter made further investigations and sought guidance from the Crown Prosecution Service. He was subsequently informed that he was to face prosecution arising from this incident. He first appeared before the court on the 7th of October 2019. Fourth admission, a broken beer glass, in brackets the sleeve type, was found on the 23rd of June 2019 in long grass underneath the signboard that can be seen to the left of the Queen's Arms in the photograph. And so you may wish to remind yourself of that while I read it. It's at page 5 of your photographs. And just check that you've got that in front of you. The upper half of the glass was missing, but the base was undamaged. Fingerprints were found on the base. They corresponded with prints of the left thumb, left forefinger, and left middle finger of the defendant. Their positioning was consistent with the defendant having held the glass in his left hand. Admission 5. On the 28th of June 2019, Joseph Black attended a identification procedure. It is agreed that the procedure was conducted properly and in accordance with all the relevant rules and guidance. He was shown 8 photograph images of 8 different men, all of whom bore a resemblance to each other. One of the images was of the defendant. Joseph Black was asked to look at the images twice without making any comment. After the second viewing, he was asked if any of the images was of the man who had attacked him outside the Queen's Arms on the evening of the 21st of June 2019. He replied, "I can positively identify man 6 as the person I pointed out to the police as I was leaving the pub that night." The person whose image was at position 6 was the defendant. And Your Honour, those are the admissions, and I now move to the summary of the police interview, which has been put down to half a page, and it's on the next page. The defendant was interviewed at midnight on the 22nd of June 2019, and the interview lasted for 23 minutes. There were 2 police officers present to conduct the interview. The defendant had a solicitor present to help and to advise him. The interview began with one of the police officers cautioning the defendant in these terms: "You do not have to say anything, but it may harm your defence if you do not mention when questioned something which you later rely on in court. Anything you say may be given in evidence." The defendant's solicitor informed the officers that he had advised the defendant to make a written statement, setting out his side of the matter and not to answer any further questions. The written statement read thus: "I was in the Queen's Arms on the evening of the 21st of June. I got there at around 8:45, hoping to run into some mates, but I was out of luck. I bought a pint and drank it standing at the bar, chatting to the bar staff. I think I may have had a second pint. I'm not quite sure. I was aware at about 9:30 that someone had been brought into the bar bleeding heavily. I don't like the sight of blood, so turned away from what was going on and finished my pint. I decided to go home. I had just left the pub when a police officer came up to me and arrested me. I didn't know what he was on about. It wasn't me that attacked this man. I never left the pub once that evening, apart from when I got arrested." In answer to all questions asked of him by the police officers, the defendant said, "On legal advice, no comment." And Your Honour, that is the case on behalf of the prosecution.
Good, thank you very much indeed, Mr. Trafford. Now, members of the jury, I promised you a break. You've had a short one already while we did the legal stuff, but I now give you another break. I had kind of penciled in 20 minutes. I've seen a video of where you are, but that's all I know about it. Is 20 minutes welcome to you, or shorter, or what? Does anyone want less than 20 minutes, or put your hand up if you want less than? Fine. I'm not going to invite more than, because you'll all put your hands up. 20 minutes it will be. And in fact, my device tells me it's exactly 12 o'clock. So we'll resume at 12:20. Good, okay, see you then. So we'll shut you out. Good. Now, Ms. Oakley, a message has come to me that you'd like to speak to your client over the Germans.
Yes, please.
Oh, that's absolutely fine. You, of course, may do so. And you know the procedure whereby that can be achieved, I think, don't you?
I absolutely do, and I want to make sure it works so that when we come back, there's no difficulties.
There you go. That's absolutely fine. Good. Then you may do that. What I'm minded to do is, I had anticipated that you might want time later during the course of the presentation of your case, but I'm going to ask you, please, to deal with any matter that may arise during your case now with your client, so we avoid having to break off again. Is that going to be possible for you?
It will be possible.
Okay, well then that's very helpful. Thank you very much indeed. Now, I also had a message that there may have been some difficulty about what happens to your client when we have the Germans. I suspect that won't be an issue now, because he'll be in his side room, as it were, talking to you, won't he?
Yes, he will.
Okay, but then we'll leave it in that way without my further intervening. Okay, it's now 12:02 on my device, and I will see you all again when I come back into court, promptly at 12:20. Good. I'm returned to court. I may be a few seconds early, I think, but I am now sitting. Ms. Eckley, Ms. Eckley, you've had an opportunity to speak to your clients.
I have, and we'll be able to proceed straight after his evidence to the next witness.
That's very helpful indeed. Thank you. Good. And then, if we're able to, can we bring the jury back into court? Not quite sure what's gone wrong. Miss Eckley, we've lost your client, I think.
We have. I will ask the technical team, please, to look at that matter now.
Yeah, sure. I can see the jury, but they're in the wrong place on the screen, which is true for me and I suspect for others too.
You know, I think they're getting the defendant in first.
Yeah, I've got the same message as you do, Mr. Strathern.
Thank
you. We'll just be patient. There we are. Good. Good. We're all back. Mr. Drew, you have unmuted yourself, I assume?
Yes, Your Honour.
Good. Okay. Thank you. Yes, Miss Oakley.
Your Honour, may I please call George Drew?
Yes, indeed. I think the intention is to move his image to a different place on the screen. There we are.
Would you like to take a note? Sorry, Your Honour.
No, you carry on, please do.
Thank you. Would you like to take an oath or to affirm?
I'll affirm, please.
If you'd like to repeat after me. I do solemnly.
I do solemnly.
Sincerely and truly.
Sincerely and truly.
Declare and affirm.
Declare and affirm.
That the evidence I shall give.
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Good. Yes, Miss Oakley.
Can I ask you please to give the court your full name?
Yeah, my full name is George Drew.
Mr. Drew, I'm going to be asking you some questions about a summer's evening on the 21st of June last year. Before I do, can I ask you to keep your voice nice and loud? If at any stage you have any difficulties hearing or seeing, either raise your voice or make the technician aware. Is that okay?
Yes.
So Friday, please, the 21st of June. Did there come a time that evening when you went to the Queen's Arms public house?
Yes, I did.
And why did you go there that night?
I just snipped out to have a beer, see if there was some friends out.
And is that a pub close to your home address?
Yes, I don't have a local, but that's closer to my address.
Can you remember what time you arrived at the Queen's Arms?
About 8:45.
Did you go there on your own or were you with someone?
I went there by myself.
And when you arrived there, was there anybody inside that you recognised?
No.
Having arrived at the pub, what did you do?
I went to the bar and ordered myself a pint.
And where did you drink that pint?
Stood at the bar.
And whilst you were stood at the bar, do you remember speaking to anybody else?
The only conversations I had was with the bar staff.
Do you remember the name of anyone in particular or not?
No.
While you were drinking that pint, did you remain inside the Queen's Arms public house the whole time or not?
No, I didn't nip out for a cigarette.
And when you nipped out, where did you go, please?
Just down the side of the pub by the sign.
Can I ask, please, that we have a look in the jury bundle at page number 5? It's a photograph that we've already seen before that shows the Queen's Arms pub. Can you see that? Can everyone see that? Can you just help us, please, Mr. Drew, where it was you were stood when you were having your cigarette?
By the sign and the tree with the boxes on the wall.
Right. So, in effect, just behind the lamppost that we can see in that area, is that right?
That's correct.
Now, by the time that you went out for a cigarette, had you finished the pint you had bought?
No, I took some out with me in the bottom of the glass.
Right. So you went outside with your pint, you had a cigarette. Whilst you were outside, did you see anybody?
No.
Did you speak to anybody?
No.
After you finished your cigarette, what did you do?
Finished my pint, left the glass outside, which was lazy of myself, and then went back into the pub.
And whereabouts, please, did you leave it?
It was left on the boxes that's attached to the side of the pub.
And we can see those, can we, in image 5 on the side of the pub?
Yes.
When you put your glass there, what condition was the glass in? What state?
It was a whole pint glass, not broken.
Can I ask you this? How long do you think you were outside for, please?
I'm not sure.
When you went back inside, did you buy another drink?
Yes.
And where did you drink that drink?
At the bar.
Having gone back inside the pub, did there come a time when something happened or something came to your attention?
A man came back into the pub bleeding from the side of his face.
Did you recognise that man? Did you know him?
No.
When you saw him bleeding, how did that make you feel?
I don't like the sight of blood, so I turned away.
Do you know how it was he came to have sustained that bleeding injury?
Not sure, I was inside the pub.
Did there come a time when you left the pub that evening?
I'd left the pub to go outside for a smoke, and then I came back in, yes.
And then after you'd gone back in, you bought a drink, and did there come a time then when you decided to go home?
Yes, finished my drink and then I left.
And having left to go home, we have heard that a police officer approached you and arrested you on suspicion of unlawful wounding. Is that right?
Yes.
Now, the jury have heard a number of admissions read to them. And may I ask, please, that we have page 6 of the jury bundle available. Mr. Drew, can you see that?
Yes, I can.
Thank you. Paragraph number 3 of those agreed facts details that you were arrested outside the Queen's Arms and that immediately after you were pointed out by Mr. Black, you were cautioned and replied, "This is rubbish. I never laid a finger on him." Why did you say that?
Because it's the truth.
After you were arrested, you were taken to the police station, weren't you?
Yes.
And you were interviewed about events that had taken place and your actions and movements at the Queen's Arms, weren't you?
Yes.
And during that interview, you had a solicitor present, didn't you?
I did, yes.
And can I ask, please, that we turn up now page 7 of the jury bundle. And from that, we know that at the beginning of the interview, your solicitor handed over a written statement to the police, didn't they?
Yes.
And that thereafter you answered on legal advice, no comment to all questions asked of you.
Yeah, that's correct.
I just want to ask you about some parts of that written statement, if I may, please. On page 7, we can see written out the written statement. And second line, 2 lines up from the bottom of that paragraph are the words, "arrested me." Can you see that?
Yes.
And what you've set out by this point is that you left the pub, a police officer came up to you and arrested you. And then you said this in your prepared statement: "I didn't know what he was on about." So you were saying, "I didn't know what the police officer was on about." Was that the truth?
That was the truth, yes.
You then said, "It wasn't me that attacked this man." Was that the truth?
That is the truth, yes.
And then you said this: "I never left the pub once that evening, apart from when I got arrested." Mr. Drew, was that the truth?
No.
Why did you not tell the truth about leaving the pub for a cigarette that night?
I just didn't want the police to think I was involved in the incident.
Where were you, Mr. Drew, when Mr. Black received that wound to his face, as best you can tell us?
I was inside the pub, stood at the bar.
I just want to ask you, please, some questions, if I may, about a witness, Mr. Wilson. In 2016, he was convicted in the magistrate's court of assaulting you with a weapon.
Yes.
Do you remember that?
I do, yes.
Can I ask you this? Since that incident, have you seen Mr. Wilson?
Not to my recollection, no.
Can I ask you this? Do you have any understanding about how he feels about that conviction?
From what I believe, he feels hard done by. He shouldn't have received a conviction, and he blames it wholly on myself.
Mr. Drew, do you have any convictions recorded against you?
No.
Your Honour, I have no further questions. Thank you.
Thank you. Mr. Trafford. You're muted, Mr. Trafford. Mr. Trafford, you're muted.
Well, forgive me for that, then I'll put the question again. My apologies. I'm sure he put it brief.
Yeah, okay. Yep.
Drew, you gave your account about what happened on that night, or very early the following morning, didn't you?
Yes, I did.
You were at a police station, I think, three and a half hours or so after Joe Black was assaulted by you, weren't you?
Allegedly, yes.
And you had the opportunity, of course, to speak to your solicitor, who was in attendance, or a solicitor in attendance, and to answer questions.
Yeah, that's correct.
And it's right, isn't it, that at that stage, your memory of what would have happened on that evening must have been much clearer, Mr. Drew, than it is now.
Yes, it will be.
Yeah. And you lied, didn't you?
I won't say I lied. I missed a section out of my statement.
Now, so what has happened since your interview and now? Should we just have a look and go through it? We know, and I think you admit, don't you, Mr. Drew, that 2 days after your interview, a glass was found at the spot, or very near the spot, where this assault took place. Yeah?
Yes.
And, of course, you accept that an assault did take place just outside that pub that night at 9:30 when Mr. Black was having his cigarette. Yeah?
Yes. Yep.
And, of course, that glass found at that spot was broken, wasn't it?
It was, yes.
Yeah. And it had your fingerprints on, didn't it?
Yes.
So that would have been the glass, wouldn't it, that you would have been at least drinking from that night?
Yes, it would, yeah.
To help us with this, or help me with this, maybe I didn't understand your point earlier, why didn't you take it back into the pub?
Plain laziness.
Not that it was smashed, Mr. Drew?
No, when I left it out there, it was full.
Now, of course, if I may move on to another topic, you don't know, do you, Joe Black?
No.
You've seen him, of course, give evidence today on this screen.
Yes.
You haven't met him before, engaged before with him, or spoken to him before?
No, never.
Yeah. Now, help us with this. You went out yourself, in fact, for a cigarette, didn't you, that evening? You were telling your counsel a moment or two ago.
Yes, I did.
You arrived at about 8:45 at the pub and you had your pint. And whilst you were drinking that pint, you went out for a smoke. Yeah?
Yes.
Well, would that have been about 9:30 then? Sort of 45 minutes or so after you arrived at the pub, Mr. Drew?
Could have been earlier. Not sure.
Not sure. But it could have been about 9:30, couldn't it?
Could have been, yeah.
In other words, Mr. Drew, you were outside at the same time that Mr. Black was outside.
No, I was sat in the pub when he came back in.
Oh, certainly you'd gone back to the pub when he came back in with those injuries, but when he was having his smoke, you were also outside, weren't you?
No, I never saw anybody outside.
And he then came back into the pub. And the next time there was any interaction between the two of you, Mr. Drew, was when you were outside the pub and Mr. Black was being escorted, bleeding heavily from the pub towards the ambulance, weren't you? You were outside the pub watching.
I was outside the pub going home.
And he pointed you out, didn't he?
Yes.
And you knew he pointed you out when he pointed you out, didn't you?
Yes.
Yes. And I think you know, and it's been agreed, that a week later, a whole week later, on the 28th of June, a man that you had never known, never engaged, never seen before, who identified you as his assailant outside the pub, then identified you again in an identification procedure a week later.
Mr. Trafford, that's an argument, not a question.
Forgive me. But you knew that that identification procedure had taken place?
Yes, I was aware.
Yeah. And so what we have is this, right, in summary, Mr. Drew, is that you gave an account on the night of you being in the pub the whole time and never having gone out? Yes?
I did, yes. Yeah.
And then you changed your account to fit the evidence, didn't you, as it arose as it went along?
I give my evidence as it should have been given the first time.
And you well know, don't you, Mr. Drew, that the reason you lied to the police that night is that you knew you did leave the pub at exactly the same time that Mr. Black left the pub.
I was inside when he got assaulted.
And you had forgotten that you'd left your smashed glass outside the pub before you came back into the pub, having assaulted Mr. Black.
That glass was whole when I went back in the pub.
And then, Mr. Drew, when you were arrested for this and interviewed, you lied to the police about what happened that night.
I didn't lie to them, I just didn't say something in my statement that I should have done.
And Mr. Drew, you're lying to us now, aren't you? Because you did assault and smash your glass into the face of Mr. Black that midsummer's evening this time last year.
No, not lying to you.
I have no further questions.
Thank you.
Your Honour, just one matter, please, if I may, in re-examination. Mr. Drew, you've been asked some questions about your fingerprints on the glass. May I ask you, please, whether you're right or left-handed?
I am left-handed.
And when you drink a drink, would you use your right or your left hand?
My left hand.
Your Honour, I have no further questions. Does Your Honour have any questions?
No, I don't. Thank you very much indeed. Thank you. Yes. Thank you very much indeed, Mr. Drew. Miss Oakley, you mentioned another witness. Do you propose to call that witness?
I do, Your Honour, and that witness, please, when the defendant has returned to his position, will be Bernie Stevens.
Yes, okay. I've received a message that the witness may not be currently ready. I need to just investigate that. I'm just going to shut you out for a minute while I make some inquiries to this. And we can, in the meantime, get the defendant back into his normal place. So if we can just temporarily and briefly, I hope, put the jury into that virtual space. So glad you've been busy doing other things, but a message has come to me that the witness has a matter that requires some discussion. Can you just be patient for a moment? Okay, it appears to have been resolved. If we can bring the jury back in and bring the witness into the virtual courtroom, please.
Would you like to?
Sorry, all now resolved and we can make progress. Yes, sorry.
Thank you. Would you like to take an oath or to affirm, please?
To affirm.
If you'd like to repeat after me. I do solemnly.
I do solemnly.
Sincerely and truly.
Sincerely and truly.
Declare and affirm.
Declare and affirm.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you.
Now, Ms. Stevens, I need to make it clear to you, as I have to all other witnesses, that although you're in your own space, you are actually giving evidence before a formal court of law. You understand that, I hope?
I do.
Good. And it's important that you comply with your affirmation to tell the truth. It's also important that you are on your own in the space in which you are. Are you on your own?
I am, yes.
Yes. And if I ask you to turn your device through 360 degrees, what will we see?
You'll see my bed and an office chair.
I see. But no other human being?
No other human being.
All right, okay, that's fine. I'll take your word for it. Yes, Ms. Oakley.
Can I ask you, please, to give the court your full name?
Bernadette Stevens.
I'm going to be asking you some questions about a summer's evening on the 21st of June of last year. on that evening, were you working at the Queen's Arms Public House?
On which evening, sorry?
On the evening of the 21st of June, 2019.
I was, yes.
And were you working behind the bar serving customers?
I was.
And how often did you work at that pub, please?
Not very often, but I'd say about maybe 12 shifts a month.
And the people that drank in that pub, had you got to know them as you worked there?
Yes.
And did you know the names of all the people who drank there or not?
I didn't know the names of all the people who drank there. Some names cropped up in conversation, and if they were regulars, then you'd remember them.
Right. Can I ask you this? George Drew, is that somebody who you knew as being a regular or not?
He didn't come in all the time, but I did know who he was. He was a very polite and nice man, so he was someone that I'd speak to when he was there.
The 21st of June, then, please, if I may ask you some specific questions about that night. Was it quite a busy night in the pub?
Yes, it was.
And that night, do you remember every person that you served?
No, not every person that I served. It was busy, so and I was quite tired. But yeah.
Do you remember if you saw George Drew that night?
I do. Yes, I did see him.
And where did you see him?
He was at the bar.
Did you speak to him?
Yeah, me and some colleagues spoke to him.
And when you spoke to him, he was at the bar. What was he doing?
He was having a beer. That's it, really. He went out for a cigarette and just had a couple of beers.
Do you remember seeing him go out for a cigarette?
Yes.
And do you remember seeing him come back in?
Yes.
Do you know roughly, and if you can't say, then just say, do you remember how long he was gone for?
Only a few minutes, not very long at all.
And when he came back inside the pub, what did he do then?
He came back, he ordered another pint and then just sat at the bar as he was before he left.
And how did he seem?
Fine. I couldn't really say. I wasn't looking that closely.
Did there come a time when you became aware of a man who was bleeding?
Yes, I was quite shocked. This man came into the pub. He was bleeding all over the place, and yeah, that was obviously quite shocking. You don't see that every day. It wasn't expected.
Sorry, my fault. When that man came into the pub and was bleeding, can you remember whether or not you saw Mr. Drew?
Yeah, because he was at the bar. He was sort of stayed at the bar as opposed to just coming and getting drinks. He looked about as shocked as everybody else.
I have no further questions. If you just wait there may be some questions from my learned friend.
Yes, Mr. Trump.
Yeah. Thank you very much. Miss Stevens, that night, of course, you knew that one of your regulars, George Drew, had been arrested by the police, taken away just outside the door of your pub that evening.
I can't remember.
You can't remember?
No.
How can I put it? The talk of the pub, wouldn't it? One of the regulars had come in with a slashed face, was taken off in an ambulance, and another one of your regulars who you knew was taken away in a police car.
I was working, so I don't really know what happened after the man who came in injured. I don't know what happened after that.
Well, is that right, Miss Stevens? I think it's right, isn't it, that you was spoken to by police officers in the pub that very evening.
Yes, I was.
And you were spoken to about the fact that one of your regulars had been glassed, if I can use that expression.
Yeah, they asked me. Well, they asked me about what people's comings and goings. That's all they really asked.
And you said, I think, and the officers asked you questions, and I think whilst they're asking you questions, Ms. Stevens, you probably saw they were taking notes of what you were saying.
Yeah.
And indeed, at the end of talking to you about what happened that night, they read back their notes to you and asked you to sign their notebook, didn't they?
I think so, yeah.
As being a truthful account of what you told them.
Yeah, I think so.
And in fact, what you said in the course of this, when you were asked about people's comings and goings, was this: "Don't be so stupid," you said. "I was rushed off my feet just serving people. I can't possibly be expected to know who was in or out of the pub at any particular time." That's what you told the police within, what, half an hour or so, one of your regulars being glassed in the face.
I don't know if the man who got glassed was a regular, but I mean, it was very busy, and you know, we were trying to serve as many customers as possible, so it's possible that I may have said something along those lines. I was quite tired and probably just wanted to go home.
Miss Stevens, I'm sure you were very tired, but you told the police that very evening that you were essentially unable to help them. Isn't that right?
I can't really remember what I said in that moment, but yeah, that sounds like something that I may have said at the time.
And that now, Miss Stevens, you come to tell us something rather different to that which you told the police that evening.
Mr. Trafford, that's another argument. Questions, please.
Thank you very much. Can I now address you then and ask you questions about what you have now told the court?
Yes.
You said about Mr. Drew, the defendant, that he was definitely at the pub that night. You agree with that?
Yes.
And that he ordered a pint and talked to you, is that right?
Yep, to me and some colleagues.
And then, of course, you state yourself that this man left the pub and went outside to have a smoke.
Yep.
And I suggest to you that he did that at about 45 minutes or so after he came into the pub in the first place, about 9:30.
I really couldn't say in terms of time. When you're working a shift like that, it kind of just turns into one long period of time, but potentially, yes.
But after he went out of the pub, he certainly came back in again.
Yes.
And very shortly, I suggest to you, after he came back in, Miss Stevens, Mr. Black, Joe Black, another one of your regulars, also came back into the pub with his face slashed.
Yes.
And so you, of course, can't help this court, can you, with what in fact happened, either with Mr. Drew or with Mr. Black, outside of the pub when they went to have their smokes?
No, I can't.
Yes, thank you very much.
Thank you. You're muted. You're muted.
Is that better?
Yeah, that's fine.
Apologies.
Don't
Miss Stevens, may I ask you this? Did you yourself at any time go outside the Queen's Arms public house that night?
Only when coming in and leaving and on my break, but not during the time that they were outside.
So when Mr. Drew was outside for a cigarette, could you see him?
No, I was busy serving other customers.
So when
he was only gone for a few minutes.
Okay. When he went outside, do you know whether or not, in fact, there was anyone else outside when he went outside?
I couldn't say, but I would suspect probably so, because it was quite busy, and he's not the only smoker. But I couldn't say how many people were there or if he was on his own.
At any time, did you see Mr. Drew that evening speaking to Mr. Black?
No, I didn't.
Thank you very much. Your Honour, I have no further questions. Does Your Honour have any questions?
Well, just one, just to clarify, if I may. Ms. Stevens, we've heard that that the man who glassed Mr. Black came back into the pub and appears to have been closely followed into the pub by Mr. Drew. By Mr. Black, I'm sorry.
Yeah.
Yeah, the man who was glassed. Now, you've told us that at some point, Mr. Drew went out for a smoke and then came back again.
Yes.
What was the time lapse between him coming back in again and the man who'd been glassed arriving returning to the pub? Can you help us with that?
I can't be sure, but it wasn't that long, because George had just sat down and ordered another beer, and I think he'd literally just been handed that beer, so it wouldn't have been that long. It wasn't like 20 minutes or anything.
I see. So it was about the time it would take for him to sit down, get served.
Yeah,
have his
I think
pint
so. Yeah.
poured. I see. That's the time scale. Okay. Thanks very much. So just that clarification I was interested in. Thank you, Ms. Stevens. If there's any questions from Oakley or you, Mr. Trafford, please ask them that you haven't. Thank you very much indeed. That's your evidence complete, and you're free to go. Thank you.
Thank you.
Now, members agree that's the conclusion of the evidence. The next stage is for counsel to address you, I no doubt, briefly on the submissions they want to make as to why the defendant should be either convicted or not. Mr. Trafford. It'll sound even better if you're unmuted, Mr. Trafford.
Moment that I'm any better judge of the evidence than you are, so I leave that entirely for you. But the prosecution case, you will no doubt conclude extremely quickly, remains undiminished by the evidence that you heard. There has been some scorn, I need to address this, poured on Mr. Wilson by not, once he witnessed this event, going back in or offering his help in some way. But members of the jury, I do ask you to cast that particular piece of material aside. Because what Mr. Wilson, we now know for sure, could do was, in fact, to identify this defendant. He was an independent witness walking past at the right time. It was never suggested that he wasn't at the right time necessarily. And, of course, he knows this defendant. He is, in one way, I suppose, in a stronger position immediately than Mr. Black, because Mr. Wilson said straight away that the moment he saw male A, or the first person shout at the second, he knew who it was. And you will, I'm sure, dismiss fairly quickly this idea that when one knows someone that one is witnessing, one necessarily goes, oh, I know they're wearing a pink shirt or a blue shirt or a pair of shorts or a pair of jeans or what type of trainers. You just think, oh, there's my friend Sarah, there's my friend Bill. One doesn't immediately think what was my friend Sarah and what my friend Bill were wearing. But the very simple reality is this, that Mr. Black, and this is not opposed in any way, was glassed that night. There was one other person outside when he was glassed. He described that person when he was glassed. That person went back into the pub immediately after he glassed him. And as we've heard only a moment ago in the last witness for the defendant, the witness for the defendant herself said that I can't be sure how long it was after Mr. Drew came back into the pub that Mr. Black came in, but it certainly wasn't long enough, as she said in answer to a question by His Honour, for him to just order essentially another drink. So, members of the jury, entirely consistent, I would suggest to you, with evidence given by Mr. Wilson, and of course, importantly, evidence given by Mr. Black. Now, I need not remind you, it's been said during the course of this evidence that Mr. Black didn't know this defendant. And yet he describes him. When he leaves the pub having been injured, no doubt in a state of shock, as will be told to you by the defendant's counsel in a moment, he was still able to recognise the person who assaulted him and pointed him out to police officers. He wasn't to know, members of the jury, would he, that was entirely consistent with the evidence of a man he didn't even know, Mr. Wilson, coming along to give evidence later. And it was, of course, his identification was entirely consistent with the identification parade that was conducted when he picked him out once again a week later. Members of the jury, all of the identification evidence in this case, beyond question, points to this defendant. I would suggest to you that each part of that evidence, the initial identification, the identification of the pub, the identification of Mr. Wilson, the identification on the parade, each of those on their own is enough to convict this defendant. But taken together, members of the jury, they are absolutely overwhelming evidence against this defendant. And that, members of the jury, is before I deal with something else. And that is the fact that when this defendant was asked what he was doing in the pub that night, within hours of having been in the pub that night, he lied to police officers. He wanted to put forward an account that was, of course, exculpatory, that rode him out, if you like, because if people believed that he was in the pub the whole evening, of course, that wouldn't be him outside. But we now know, members of the jury, and he wasn't to know this, he left his glass outside after he smashed it into the face of Mr. Black. Now, at the time of his interview, of course, on that evening, he wasn't to know that. And, of course, since that glass has been found, since that glass was smashed, since that glass had his fingerprints on, this defendant has to change his account and give an innocent explanation about why he left the pub. So, members of the jury, in addition to all those strands of the prosecution evidence we suggest that points individually and collectively to this defendant's guilt, one can look at his own evidence and now, indeed, the evidence of his own witness to prove that his account is lying. Now, of course, and you'll be reminded of this by my learned friend Miss Oakley, and I'm sure you'll be reminded of the judge's legal directions, the burden is upon the Crown and remains on the Crown throughout to prove this case that you can be sure. And members of the jury, as I've indicated and I repeat, either individually or taken together, all these strands of evidence point unquestionably to the guilt of the defendant for attacking this man and committing that unlawful wounding that night 1 year ago. And that's all I have to say. Thank you very much.
Thank you, Mr. Trafford. Miss Oakley. Again, I think you would be more effective as an advocate unmuted.
Members of the jury, the critical question that each one of you is going to have to ask yourselves when you retire is, have the prosecution made me sure that George Drew was the man who lunged at Joseph Black with a glass, causing that jagged wound to the left side of his face? His Honour, in due course, will take you through directions on the law, and they are directions that you must follow, not as a special favour for Mr. Drew, but because the law requires you to do so. They are, in this case, vitally important, because they are the basis upon which you will examine the evidence in this case. His Honour will specifically direct you that you must be cautious, because experience has shown that any witness who has identified a person can be mistaken, even if that witness is being honest. And you can only rely on the identification evidence if you are sure that it is accurate. And that, members of the jury, is what you are going to have to consider in your retirement. So how do you make that assessment? Well, you have to consider the circumstances very carefully in which Mr. Drew was identified. And in this case, the evidence comes from, you may think, two witnesses. It comes from Mr. Black and from Mr. Wilson. And the identifications they make and the considerations that you will apply to each of those two are different. What do I mean by looking at the circumstances? Well, you may think commonsensically that really applies only to the evidence of Mr. Black. You will need to consider how long he had the male that he says was Mr. Drew in his sight for, whether or not he could see his face, how clear his view was, whether he'd seen him before, because those are the questions that will assist you in assessing the strength of the identification. Put simply, if you've seen somebody before and have had the opportunity of observing them over a period of time without any obstructions and can clearly see their face, you may be right that the identification will be stronger. But when making that assessment, you will need to very much take into consideration any weaknesses. Weaknesses that include the following: whether an incident was unexpected, whether it was fast moving, or whether it was shocking. And you will, as far as he is concerned, have to be clinical. You will no doubt have sympathy for him. He has sustained a serious injury to his face. But take special care. Mr. Black, may he be mistaken in the man that he pointed out to police on the 21st of June? Well, you may think that actually his evidence really does assist you in that, because he told you this: I can't describe him in detail, I can't describe him in depth, I can't remember specific details. All he could remember.
Miss Oakley, we're not hearing you again. Have you inadvertently muted?
No.
I can hear you now. Just repeat the last sentence.
When you make your assessment, you may think, in fact, Mr. Black has really done the hard work for you, because he told you, in fact, that he couldn't describe the male that had attacked him in depth or in detail. He couldn't remember specific details. He couldn't, and you may think this is very important, he couldn't describe his face. When you think about how you may make an identification, isn't that the very type of feature that you may be looking for? Whether he was wearing a short-sleeved top or a pair of blue jeans, pretty nondescript clothing, that you may think won't help you in deciding whether or not he has made an accurate and honest identification. He told you also that he only saw the man for a moment, that it was unexpected, and that afterwards he was overwhelmed. And what he told you was the person that he picked out and pointed out to the police was somebody who was wearing the same attire. Well, be very careful when you rely on that evidence in order to convict Mr. Drew. You also have heard that he attended an identification procedure on the 28th of June, and he was asked very specifically in that procedure whether or not the man in the images could be seen. And he was asked this: if any of the images was of the man who attacked him outside the Queen's Arms on the evening of the 21st of June. And he replied, you may think, very carefully, I can positively identify man 6 as the person I pointed out to the police as I was leaving the pub. Well, that is not in dispute, members of the jury, because everyone accepts that Mr. Drew was outside the front of the pub at that time. You also may want to take into account the following, because it's his evidence. He pointed out Mr. Drew on instinct. Well, you have a think about that and the circumstances in which he made his identification, the alcohol that he'd consumed and how it made him feel, that it was fast moving, and that he didn't have much of a chance, you may think, to view the man. How possibly could you be sure on his evidence? And members of the jury, next, dealing with Mr. Wilson. Be careful there, I suggest. Be careful, because what you have to decide there is not whether or not the identification is correct in the terms I've just set out, but you have to decide whether, in fact, he is being honest. Because he didn't say a word to anyone until the 3rd of July, and at a time when he'd learned that Mr. Drew had been released without charge. Well, who was he talking to? What information had he learned? Is that why he's able to describe what had happened? But why, if you saw what he described, would you not go over and offer assistance? Why would you not go over and say, listen, I can tell you the name of the man who just did that to you? Why didn't he do that, members of the jury? Well, the defence admit because he wasn't there. And you'll remember the evidence of Mr. Black. He didn't see anyone else outside or anyone else walking along the road that night. Of course, when making your assessment, you're also entitled to take into account Mr. Drew's evidence and that of Bernie Stevens. And you may think, from the moment he's been confronted with these allegations, that Mr. Drew has steadfastly denied them. This is rubbish. I never laid a finger on him. It wasn't me who attacked him. What more could he possibly say? And the prosecution placed great weight that Mr. Drew denied leaving the pub that evening. Well, you'll have to consider that very carefully, because we have experience, and you may think that just because somebody doesn't tell the whole truth, it doesn't mean they're lying about everything. Sometimes people lie for other reasons. And you may think, in fact, he was pretty candid about why he did. He didn't want the police, in effect, to put 2 and 2 together and come to the conclusion that he was the responsible for that injury. And finally, Miss Stevens. Well, you'll assess her. She was somebody who simply worked at the Queen's Arms. You may think no axe to grind. And she told you, didn't she, that she remembers seeing Mr. Drew in the pub that night. And she saw Mr. Drew's reaction when that bleeding man came in. He was as shocked as all of us. That's what he told you. And you'll remember her saying that she'd seen other people she assumes outside. So people clearly were in and out having a cigarette that night. He was visibly shocked. So remember that crucial question you're going to have to consider. Have the prosecution made me sure? And if, having considered all of the evidence, you think maybe it was George Drew, probably he did, possibly he did, he could have done, he might have done, or even it's more likely than not that he did. All of those mean you're not sure. And members of the jury, when you find that you cannot be sure, you must return a verdict of not guilty. Thank you.
Thank you, Ms. Oakley. Now, members of the jury, it falls to me now to sum the case up to you, but you will have some assistance in that, because if you go to your bundle and page 8, you will find there if they make you sure of the guilt of the I'm so sorry, again, I'm getting messages. Let me pick up. You want to think about how good an opportunity he had to make a good observation of his attacker. Obvious questions will arise. I pose some of them, but there are others that you'll think of. How close were they to each other? What was the light like? And maybe critically here, how long did the observation last for? Maybe add to that something that's arisen in the evidence as you've heard it. Was Mr. Black actually identifying the person who had attacked him, or was he, in the identification procedure, identifying the man he picked out outside the pub? And are they necessarily the same person? But of course, on the other side, you want to think about what supporting evidence there is for the observation. And here the defendant's fingerprints on the very glass that was put into Mr. Black's face arise. This presents, I've noted here, two questions that they are actually the obvious questions. Why were they there at all? And why did Mr. Drew not tell the police about that occasion when he went out of the pub prior to the time he went out and was arrested? But the message is that you need to take care over this sort of evidence, identification evidence, to be aware of the possibility of
check 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Monday, Tuesday, Wednesday. January, February, March. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1.
I've returned into court because I understand that the stream is now working and those in the public gallery can both see and hear what is going on in court. I just need reassurance that that is so before I go any further. Good. I know I have that reassurance. What I want to say now is for the benefit of those in the public gallery whose ability to access the proceedings was diminished during the course of the summing up. I apologise for getting on with the summing up. Despite that, I explained what I did in this way. It seemed to me important to allow the jury to retire and get on with their deliberations. And secondly, in the particular circumstances, it was the lesser of two evils. Those particular circumstances being that what I said to the jury is actually available to all of those in the public gallery who have, I'm told, access to the jury bundle. So if I could ask those who are interested in what happened, and I'm sure that's many of you, to go to page 8 of the bundle. You will see there, and available for your perusal at your leisure, the legal directions that I gave to the jury. If I didn't read every single one of them verbatim, then the difference between what I wrote and what I said is of no significance at all. So you may rest assured that the legal directions which I gave are the directions that are available to those in the public gallery. And I repeat and stress that if it were otherwise, I would have been constrained to wait for your return, as it were, to the process before I summed up. I add only this, that those of you who choose to read the legal directions will observe a total absence from them of any reference at all to the evidence. That was deliberate in the sense that this is a short case in which the issues are crystal clear. But I did nonetheless, and these do not appear in the written directions, add to the jury some brief words to identify the issues in the case. Before I do that, I have worked on the assumption that the content of the pages 8 and I think 9 of the bundle are actually available as I speak to those in the public gallery. I'm pausing to be told I'm wrong if I am wrong. No, I get a message that I'm not wrong. Okay, good. Therefore, I tell those in the public gallery now that I added to what appears in writing a brief identification of the issues in the case, telling the jury that the issues for their determination were whether it may be that the identification by Mr. Black was honest but unreliable, whether the identification by Mr. Wilson was unreliable or, more importantly, perhaps malicious, whether the account given by the defendant and his witness was sufficient to throw doubt on the prosecution case to the point that the jury could not be sure of guilt. And I'm reading from a note as I say this. I speak now from recollection as I say what follows. I said something, I think, to the effect that the jury would want to look at the identification evidence first and ask themselves whether it was either reliable or truthful, and in considering that, look at the whole of the evidence that might inform their determination of those issues. Now, I've said what I propose to say, but I invite you, Mr. Trafford, Ms. Oakley, to add anything to the narrative that I have given that I have omitted. Mr. Trafford, anything that not repetition, but addition, it is necessary.
You've summarised the problem.
Thank you. Ms. Oakley?
I have nothing further to add. Thank you.
Okay, good. Then with further sincere apology to those in the public gallery, because I generally, truthfully think that their presence in this exercise is of fundamental importance, but with a plea to be understood as to why I proceeded the way I did. As I say, offer my apologies, and I hope the deficit has, as it were, been restored. That's all I propose to say. I'm now going to rise. I have to say I'm not absolutely clear as to how I will be told if and when the jury reach a verdict. Forgive me. I'm happy to receive it by email or by WhatsApp or by whatever means is most convenient. I propose, subject to anybody's better judgment, to fulfil the expectation of the jury that they will be away within a reasonable time, to bring them back to court in about an hour's time, unless they have in the meantime reached a verdict. And by that I'm saying really 2:45. Now again, I'm pausing to be corrected if the jury's expectations are any different from the ones that I have identified. And I will receive correction either orally in court or by email or by any other convenient means.
The only issue, if I may raise it at this stage, Your Honour, I suppose arises from the slight hitch a moment ago, which is, of course, public would normally be summoned when back the usual all parties, etc., that we hear in court. So I wonder whether one should revisit this at, should we say, not before 2:15, and just so people can come back and see if anything's happening or something like that, because otherwise there isn't another way of doing it. Just a thought, no more.
Well, I see the difficulty, but I mean, the problem is that, as you say, in the real world, people physically leave the public gallery in the hope that somebody will be good enough to put over the tannoy in a form that is audible and broadcast to a place where the public might actually be at any given time, that the jury have reached a verdict in court, whatever number it is. I'm not altogether confident that actually really happens in the real world all that much. But honestly, I do think that those in the public gallery here, I mean, the better schemes may have to be devised, but would rather have to take their chance. And if they want to have a sandwich or a coffee or something, might need to do it with their eyes glued to the screen. I can't think of a better way of doing it. Can you? I mean, a 2:15 is fine, but what are the jury reach a verdict at 2 o'clock?
Well, one often has the jury won't give a verdict between 1 and 2, I suppose, is a direction that's often given. But
that's only because greedy people can go and have their lunch.
Well, that probably me.
Yeah.
I wonder if we could say nothing will happen before 2. Perhaps that, at least a small compromise.
Well, okay, that's a fair point. Okay, but what I will say is that I think there's enough for the jury to be talking about to make it unlikely that there will be a speedy verdict in the case. Is that just my individual judgment? I shouldn't really ask. No, I mustn't ask counsel. It's not fair. And I'm no, please. I'm not going to ask you. You must express views about your own case, but I can. What I will say is I won't take any verdict or deal with any jury question if there is one before 2:10. How's that? It's 25 minutes.
Thank you.
Okay, and if the jury do have a verdict or a question, can they be told that we are ourselves taking our own break? But we'll deal with it at 2:10. It's good. If that's convenient to everybody, I will rise and we'll sit again at whatever time I just said, 2:10.
Thank you.
I've come back into court. I see Miss Oakley's not with us. Miss Oakley is with us. Good. Just for a catch-up, really. No news from the jury, I'm assuming. No. I assume that because I know you would have let us know if there were. Okay. Can I ask, have the jury been given a cut-off point? Not to put pressure on them, but so they know at what time they'll be free to go. You're muted, I think. Catherine, I think. Muted. You're muted. Do you want to try again?
There's a message from Jodie on it.
Ah. So there is. Yes, okay. I'm told the jury have been told 3 o'clock. I mean, I'm open to suggestions, but I'm disinclined to, as it were, say, oh, well, we'll try again in 15 minutes and 15 minutes after that. I mean, just in case that the jury do reach a verdict within the next 15 minutes or so, unfair on them to keep them longer than they need to be here. And
Sorry, this is Mike Rugg speaking.
Yeah, hello, Mike. Yeah.
I'm just asking for an update from the jury site just to see exactly what they have been told.
Okay, that's fine. Thank you. Well, I've had a message from elsewhere that the jury have been told that their release time, as it were, is 3 o'clock.
Would it be sensible, and forgive me for...
No, that's fine.
...making this, if the public gallery can hear this, and I simply don't know whether they can or they can't, I assume they can.
I believe they can, because a message I have received, I could only have received from somebody who's in the public gallery, and that person there must have heard what I've been saying.
So would it be sensible just to remind the public gallery to keep an eye out? If they begin to see people on the screen, that means something will happen. If there's nothing on the screen, that means nothing happening.
Yeah, exactly that.
Because we are likely, are we not, to come back in at least a few minutes before the jury once we receive some notification that they may have come to a verdict. And I think Your Honour has pressed video off. Or perhaps you just don't like my submissions, I don't know.
Sorry, Judge looks like he's just disconnected. I'll just see if we can get him to just connect back in again.
Well, I think the point's been made, so...
Hi, can you see and hear me now?
Yes.
For some reason, my whole thing vanished. But anyway, I'm back. I can't think where I last said. The thought I had, well, I've expressed it. Strafford, there's something you were suggesting, I think, when everything went blank on me. Could you repeat it?
But forgive me, Your Honour, merely, yes, which I'm sure is clear to those who are watching, that we're likely to come in before a few minutes before the jury, once there's an indication of them coming. So for those in the public gallery who are doing other things but have this in the background, once they see anybody come up on the screen, a sort of live nodding head, if you like, then they will know that something is about to happen.
Yeah.
We're off in the meantime, that means nothing's happening. I've received the same message as you, I'm sure, which is the estimate of the jury was given from 10 till 3.
3 o'clock, yes. Quite.
We lost. Yeah.
Yeah. I mean, the problem is that there is, whereas in the conventional court setting, there is at least some mechanism for disseminating information to the public that something's going to happen, the tannoy, or sometimes just word of mouth. There is no means of disseminating that information to the diverse group who are in the public gallery.
Well,
and it may be that for the future, if there is to be a future, that some mechanism might have to be established, even if it's nothing more exciting than a WhatsApp group or something. But given that we are where we are, and given that it is important, as I repeat, that the public gallery have full and proper access to what is going on, and to avoid any risk that they may miss out on some important part of the process, I frankly can't think of any better solution than to say to us and to them, you're just going to have to sit looking at your screen for signs of activity. And as you, Mr. Strafford, have said, those signs of activity will be evident because our faces, I hesitate to use any adjective, but our faces will appear on the screen as an indication that something's going on.
Yeah, my hitherto dark face now lightened, but
yeah.
There is a suggestion that a slide can go up, saying they're on their way in some way. But of course, the reality, Your Honour, in court, as I'm sure Miss Oakley, Your Honour's been on the bench for so long, maybe it didn't. Forgive me for putting it that way. I didn't mean to be impertinent.
It's quite all right.
Simply in court these days, summoned, there will be an announcement that normally says all parties having anything to do in the case of Crown against whoever go to court 3. You don't actually know whether it's a question or a jury, unless you've got a tip off from somebody. It's very unlikely.
No, I understand that, but I'm just describing the process by which people are informed that something of interest has happened. The slide is a suggestion, but and it's helpful, but it doesn't get around the difficulty it is that people who want to know what's happening will have to be looking at their screen, whether a slide comes up or our faces come up. It's the same.
Or in real life, listening to a tannoy, which they may not be.
Yeah, but we haven't got a tannoy, so we're kind of trying to...
Yeah.
It has to be quite loud tannoy, I'd have thought, to reach everybody who's in the public gallery, who are no doubt in all sorts of different parts of the country. This, no doubt, has gone viral and is being watched from the Orkney Islands right down to Land's End. Who knows? But whatever it may be, we do not have a means of dissemination, and the only alternative is either to create the little holiday that I created until 2:10. We can't keep doing that, or to say, sorry, you're going to have to sit looking at your screen. I can't think of anything better. But what do I know?
They just have to be, those people who are interested are likely to be interested from an area where they have a screen. They're likely to be doing whatever they're doing near a screen, whether it's work or whether they are lucky enough to be at home doing something else. So one assumes, perhaps, that once our faces, heads, whatever expression come...
Well, there'll be signs of activity, and that will alert people that something's happening. Yeah. Okay, well, I can't think... I mean, if nobody's got any better suggestions, and I can't for the life of me think that there could be, we'll just have to sit patiently, get out your novel, your crossword, whatever, who knows, and be patient.
Thank you very much.
Okay, fine. I shall virtually rise, get on with my knitting or something. Okay, thanks very much for coming into court. I've had this question from the jury, which I will read to you, and I'll read my reply. It reads, Judge, in paragraph 6.3 of your advice, you state that the glass was specifically the one that was, quote, put into Mr. Black's face. Is this certain? Was there evidence we didn't see making this link? I have simply responded, thank you for this. I'll bring you back into court to answer your question in a few minutes. It takes a bit of time to get everyone sorted, and I'll have to discuss your question with counsel, so please be patient. It's I think, a good question. The link seems to be a fairly obvious one, that it was a broken glass, consistent with it having, consistent with anything. It was a broken glass found in the exact area where the attack took place. And the inference is one the jury could draw, which nobody has suggested they shouldn't. How's that?
Miss Oakley's on mute.
I know, but she can hear. But Mr. Trafford, anything you want to say to that?
The question is, was it the glass? The answer is, we can't say it was the glass, but you can infer from its presence at that place.
You're just repeating what I just said. But I mean, is there anything to add to it? Yeah. No. Okay, Ms. Oakley, unmute yourself and share your wisdom.
Your Honour, all I would ask you to do is to remind the jury of the admission number 4, and that is that the fingerprints on the glass were consistent with the left hand and consistent with him having held the glass. Yes. He accepted he was left-handed, so the fingerprints don't automatically lead to it being the weapon, but of course it's a matter for them.
Yeah, okay. I mean, I have the argument that the evidence is that the complainant turned away to his right, exposing the left side of his face to his assailant.
There's no evidence he turned to the right, he just turned.
No, there is, because he got the wound to the left side of his face, and he turned away from the assailant, who was between him and the pub.
That is our case.
Well, that's the evidence. That follows, I think, doesn't it? But I take your point that there is no direct evidence that the glass was the one used. It's a matter of inference.
Correct.
I think that's your real point, isn't it?
Yes.
Yeah. Okay, well, I'll deal with it in that way. I mean, I wouldn't bank my pension on you getting a kind of it's only inference sort of hint to the jury. It does, I confess, seem to me quite a powerful inference, but it's a matter for them to draw it. And I shall make that clear to them. I mean, either to draw it or not to draw it. Okay, jury back in then, please. Thank you for your question. I'm just going to read it back so that we all know what the question was, and that the answer that I give to it is a proper answer to it. You draw correct attention to the assertion in the directions that I gave you that the glass was specifically the one that was, quote, put into Mr. Black's face. And then you ask, is this certain? Was there evidence we didn't see making this link? The answer to the second question is there is absolutely no direct evidence, I'm using the word direct evidence, to make that link. That's absolutely right. The prosecution assert that the finding of a broken glass in pretty much the exact place where the attack took place and given the attack involved the breaking of the glass, prosecution say that the inference that that was the glass that was used to inflict the wound is a powerful one that you should draw. There is, they would point out, no evidence of any other glass being found there of that kind or of any kind. But Miss Oakley makes the argument that whilst that's an inference that it's open to you to draw, then nonetheless, in all of the circumstances, it's not one that you should draw in the absence of any direct evidence. So what I'm saying is that the assertion in the directions, and it's entirely an assertion made by me, is based upon the powerfulness of the inference that it was the same glass. But I do need to stress to you, as I made clear to you in an earlier part of the directions, that these questions of fact are questions for you to determine, not me. And if you don't regard that as a safe inference, then it's perfectly open to you to reach that conclusion. I hope that makes some sort of sense and provides some sort of answer. There is no other evidence that's been concealed from you, and the assertion that it's the same glass is an assertion based upon inference. And it's a matter for you, ultimately, whether you think that's an inference that should be drawn. I hope that is a fair and balanced answer to your question. Good. Okay. I'm going to ask you to retire and resume your deliberations. But on a practical level, I know that you were given some broad indication as to when your duties will be finished in this case. We're all of us quite prepared to, from our perspective, to go beyond the time that you were told. Could any of you, if it is a problem for you to go on, say, for half an hour or so longer than you were promised, if that would be a problem for any of you, could you raise a hand and let me know? Okay, the 3 o'clock, as it were, deadline is one that you need to abide by. Is that it? Yeah. Okay, well, that's fine. Well, I'm going to ask you to retire and deliberate further, but it won't be for terribly long, because I will be loyal to the undertaking that was given to you, and I'll bring you back into court in around 10 minutes or so. Okay, thank you. If you retire, if you will be retired, as it were, by being sent back to your virtual or real space. Thank you. Good. Since I was speaking to counsel really, but since we are doing the best we can to replicate the real world, I would not regard it as a proper reason to discharge a juror because he was unable to sit for that little bit longer and to do so in breach of a promise he'd been given as to the time that the case would finish. So I think we will have to make do with what we've got. Anyway, I shall return to court in about 10 minutes' time at 5 to 3 to see what, if any, verdict we have. Okay, I'm, as you can see back in court, the jury are being, I think, assembled into their given seating, and they can be brought into court and asked the usual question as to whether they've reached a verdict in which they have all agreed. Okay, I'm told the jury are ready. They can be brought into court. Yes, thank you. Madam Clerk, you are muted, I'm afraid. Still not hearing you. Still no joy.
I think I may have been muted by the controller.
Here you are, you're back. That's fine. Perfect. Yeah, thank you.
Apologies,
good.
I think I was muted by the controller.
Yeah, that's fine.
Will the foreman please raise a hand? Mr. Foreman, will you please answer my next question, either yes or no? Have the jury reached a verdict on which you are all agreed?
No.
Okay, thank you very much. In the particular circumstances that you're familiar with, I'm now formally going to discharge you from delivering a verdict in the case. But and so the trial is now over. A judge would always, in these circumstances, and I absolutely do now, thank you for your service as jurors. I usually would add that you had no choice, because jurors don't, but you did. So thanks are always sincere, but to you, because you're volunteers, even more so. Thank you. I hope you found it an interesting, albeit incomplete, experience. And I hope you found the virtual, remote nature of it not a barrier to the understanding of the case and your ability to deliberate on it constructively. I hope. Can I just ask you this questioned. It's just idle curiosity. The next step would have been, at some point, to give you a majority direction, allowing the court to accept a verdict upon which at least 10 of you were agreed. If you'd had that direction, Mr. Foreman, would you at this stage have reached a verdict? You can unmute and say yes or no.
Not at this stage.
You know. Okay, right. Yeah. Again, in the real jury world, you could never, ever be asked this question, certainly could never answer it, but this isn't the real jury world. Tell me what way you were leaning, but what's the division between you, or had you not actually come to taking a vote?
At this point, I believe it was 5-7.
Yeah, okay. So no point in asking which way, because you were pretty much evenly divided. Yeah, good. I'm not going to ask you any more questions. Other than, well, did you find it helpful and interesting? The answer to that's yes, by the way, but I hope, I very much hope that you did. I think, somebody will tell me I'm wrong, but I think at this point, having given you an absolutely sincere thanks for what you have done in this important experiment, I think that's it so far as the court is concerned. And I think that what I need to say is goodbye, really. I think we're going to shut you out, unless there's something more that I need to do. Is that just a nice wave goodbye? That was only, yes, fine, good. Okay, well, goodbye to you all, and many, many thanks. Thank you. Good. Now, I think the next thing is that we're going to have some sort of discussion amongst ourselves as to how it all went and how it could be improved. What I will do now is myself, as it were, rise and await further instructions. Assume as I do that we're going to have the washdown on this platform. Is that right?
No.
We're not.
Judge, there's a separate link that's been sent round.
Oh, is that? Oh, right. I haven't seen that. By email?
By email.
Right. When did that arrive?
The public gallery is still on.
Okay, that's well, the trial is over, and I suppose it strictly probably could be shut down, but there's nothing secret happening here.
Sorry, this is the engineer speaking.
Yeah,
I think the decision has now been made that we actually are going to do the wash-up here in the Zoom call.
Okay.
Sorry, here in the virtual court. Here in the virtual court. So use your links as they are. Apologies.
Okay.
So we will be meeting here. Would you like me to drop the public feed?
Yes, the trial is now over, so you can. I repeat the apology to the public gallery about what happened during the summing up. But I hope everybody understands it, and I hope the experience was not, as I say, diminished by what happened. And so I will formally say goodbye to the public gallery. Thank you very much for watching us all, and I hope you found it interesting.